Yes, my lord. May I have a lordship kindly to mention, my lord, item number 105. My lord, urgency is this, my lord. My lord, appellant is not getting salary, my lord. For a long period, he is not getting salary. He is an assistant teacher of the school, my lord.
He's
I am
not
praying
getting
for
a salary.
upgradation, my lord.
105.
105, my lord.
Yes.
Affiliate side.
You have given notice.
Yes, my lord. Upon service of notice. But my lord, notice was given, my lord, to mention it on Monday, my lord.
On Monday. Then
Yes.
come on Monday. Mention on Monday.
No, my lord, last Monday, my lord. Last.
Then you give a notice, proper notice. But when this you give a proper notice, let it their presence you mention.
Yes,
Just call the list.
Extreme urgency, my lord, I am mentioning item number 137 of your lordship list. One is an order passed by the Honorable Justice Obijit Gangopadhyay. I have preferred this appeal. My lord, it is a private school. My lord, the district inspector of the school has also given a letter to that effect that no DA, the school is running without any financial assistance. My lord, Justice Obijit Gangopadhyay hold that it is a private school, it is not maintainable. Still directed the Director of School Education to consider the a case of the petitioner and to pass an effective order. And they are time and again are not calling us for this particular settlement to be done because the staff has been suspended for hitting the principal with a cutter. So and the criminal case is going on before the Shirampur code under section 323 and 320.
So appeal is
So this
pending.
is the
So
11th July, they have called us and we have given a letter. We have preferred an appeal, and thereafter we have served everybody.
we'll take it up. Don't worry.
137, my lord, I am praying for an upgradation, my lord.
We'll call it. Don't worry. There is no contempt, so no problem.
Content, my lord, but
Yes, call the list.
My lord, this is
Why has come?
my lord. We have filed an application. The simple thing is that your lordships had disposed of the appeals by way of an order. My lord, the only thing is the petitioners, appellant's petitioners, what they sought was to be kept apprised of the status of the arbitration and to be informed to be given a copy of the award if passed by.
Copy of the award you are not concerned with.
My lord, the
You are
point
not
is we
concerned
are concerned because
your Citibank Bangladesh is there. You can always find out from them.
but they are not party to the arbitration either, my lord. They are Citibank Bangladesh also will not get to know when the award is passed. The award is strictly between KSE Electricals and the government body in Bangladesh.
So how you are concerned with this?
My lord, our chances of recovering the amount that we are out of will completely depend on what they are awarded in the arbitration.
Where the
Lordship,
amount
I am appealing for the respondent number 1. Your Lordship, while disposing of this matter, it fell from your Lordship that they can always communicate with the respondent number 2, that is the Bangladesh entity, regarding the update with respect to the arbitration, your Lordship.
But my
And
lord,
because
we
they are
not-
party to the proceeding, your Lordship.
My lord, we are that Bangladesh entity, the rural electrification board has nothing to do with us. They have not even bothered to cooperate with us.
This amount was given to by Citibank
Bangladesh to the rural
So, yes,
electrification
so
board.
Citibank Bangladesh, you can always find out from Citibank
It's a
Bangladesh.
privy to
But
the
my lord, Citibank Bangladesh.
You are not informed. We are not required to be informed. Sit down.
My lord, it's an innocuous
That's all.
Absolutely, your
You are
Lordship.
not
We can
entitled
pass
to
it.
that.
they have so far not given us any updates as to
No,
the
you
arbitration.
asked
We
for
have
an
not
update,
asked.
they will give-
We've
take
asked, madam. They have not given us
Dispose of this
anything.
application. award is passed. That's all. If any award is passed, you inform them. award is
Lordship would
passed.
recall, they are not concerned with the final award. So far as Lordship recalls in the interim award, the
They
direction,
say that this amount was not deposited with them. That's the thing.
that is not, my lord.
Absolutely.
In fact,
absolutely not.
Can be
in
with
fact,
any other
in fact,
bank.
my lord, the
That's it.
interim award says that with Kolkata, Citibank, Kolkata or any other bank.
Or any other.
Now,
bank.
my lord, I told your lordship on that occasion also that we also know that it has not been done. They are not doing it. So
If
we are
you're in-
trying to enforce it in Bangladesh.
Yes, if you're intimating them, they want to know what is the stage of the award so that they can take appropriate
But
steps.
that option they always have, my lord. Let them write a letter, we will intimate.
If they are saying that in spite of requesting, you are not furnished. That's
We
their-
have done so. We have
Oh, yeah.
specifically emailed.
Nothing has come. What will
We
be
have
furnished?
communicated. I will give.
Have you written a letter to them?
Yes, we have written to
When?
them.
When?
Mail করেছি।
When?
Mail করেছি তো।
When? You have not written a single letter to them. Why you are making this?
What is
My lord, let them undertake that we will supply. We will
Undertake.
No, undertake, I will give no undertaking.
Well,
We will be we will ask. We have asked several
Appeal has
times
been
before, my
dismissed.
lord.
They can't.
My lord, we have asked several
This
times before.
application-
They have not given us, they have not cooperated at any stage of this process.
This application is premature.
Yes, three
Yes,
separate
three
appeals.
separate appeals were there. On all of them same.
Yes, next.
Main order was also common order.
Yes, and number two. Four.
Two and three same.
Four.
We have also prepared our notes. It's that issue that Suomoto transfer of Suomoto really.
কোনটা?
একটা নোট আছে ওটা নিয়ে আরেকটা taking it back because that last point which I argued now we have put that in also
Yes, give us no problem.
এটা ফেরত দিয়ে দিন আমি আরো ফ্রেশ নোটস করে
Give us.
I'll just কোথায়
প্যাজিনেট করছি ঠিক আছে প্যাজিনেট করুন
Yeah, they will. We have fixed this for your traders to.
sorry Malad.
One thing, who is for the official liquidator?
My learner from this.
Sir, Debjani Mitra.
Now, there is one matter. In the
At
other
4-6
matters-
only.
Have you taken the views of the secured traders on this?
In my matter, we have not taken,
But you are supposed to obtain the views of the secured
yes,
traders.
Madam.
Why you have not obtained?
But
Once an application is filed for transfer or other the order is there, you should have also the views of the secured traders because the purpose of both the acts are different. That is what weighed with the learned single judge. The purpose of both the acts is different. So
maybe
in all
come
cases, it may not be that on an application it has to be transferred. It depends upon the stage of the proceeding.
in my case, your lordship, only the valuation has been done. The
So-
sale is still
So
pending.
that's yes.
Yes,
So the
madam.
purpose of section 7 and 8 is different.
And the claims have also been invited, your lordship, in my case. And there are
But-
many secure creditors in
But
my.
it may not.
Our argument is Malad has to also interpret the language
No,
of the
you see,
section.
Section of the purpose of the two statutes has to be
Purpose
because,
is different.
no, because it may not wholly dependent upon an application to be filed for transfer. For the precise reason that now that section 7 and 8 of the IBC is the purpose is to revive the company as far as possible, if it is possible, even if there is 1%, unless it results in the death is inevitable, the corporate death. So this is a point which
My lord,
needs to be addressed.
my lord, that is the point, my lord, which is correct, my lord, under the IBC. But we are, my lord, not on that because someone has to, my lord, why this I'm sorry, my lord, I'm so sorry, my lord, the purpose has to be when someone wants that purpose to be done. Otherwise, there's no purpose. It's not, my lord, the court who will, my lord, then say that yes, the company should be revived or not.
That's why if an issue arises, you have obtained the views of the secured creditors on this. Because one of the secured creditors has come and say that this has to be transferred. This has to be
My lord, he
transferred.
has to make an application. Then my lord would have considered.
Whether application is necessary or not.
Yes, that is, my lord, our submission because otherwise, my lord, the
that will
language of the section wouldn't have been there.
But it may not be in all cases that that it is necessary.
Has to be because otherwise, my lord, any stakeholder has to think. Any stakeholder, my lord, kindly see, my lord, the logic also behind, my lord, retaining it before the company's court. Because any stakeholder has to think that, my lord, it should go for revival. If not, then, my lord, under the Companies Act, liquidation follows. Winding up follows.
But the purpose of there is a paradigm shift from the concept we have in 2019.
I agree.
And the IBC.
Yes, my lord.
So if the IBC is there and
Yes.
if the two objects of the acts are required to be taken into consideration, then IBC certainly has a primacy over the 2013 Act.
No difficulty, my lord.
If the primacy is there, then
Yes.
that section has to be interpreted in a manner which will be beneficial to the company. It has to be.
Someone has to come and say it's beneficial.
No. That is why in one matter, the secured creditor said that it has to be transferred.
No,
He has taken.
there's no application here.
May not be an application, but the stand they have taken here. So whether an application in formal nature is necessary or the court still have a jurisdiction discretion or not.
My lord, that's the argument which we're making. That's the argument. My lord, my submission is, my lord, if court on its own could have done it, two reasons why, my lord, the court shouldn't do it. First, my lord, that the language of the section doesn't, my lord, really, my lord, contemplate that, my lord, the court can do it. Otherwise, it would have been easy for legislature. First. Second, my lord, there is still residuary jurisdiction in the company court. Then, my lord, all matters would be transferred. All matters would be transferred. There's no reason to why, my lord, still retain a residuary jurisdiction, my lord, in the company court to, my lord, wind up companies. That residuary jurisdiction is also important. Otherwise, my lord, what's the point?
Why you have not convened a meeting of the
Your
secured
lordship,
creditors?
if your lordship kindly takes up the status report filed in respect of item
Have
number
you- have
6,
you
we have
con-
already given the notices to the secured
Have
creditors
you
pursuant to
convened?
the court's order.
Have you convened a meeting?
No, we have not
meeting
held
of
a
the
meeting
secured
with them.
creditors
No,
to have their response on the order? You are required to. You are representing them. So what is the
it's only
response?
the notice, it is at the notice stage. We have only issued notices pursuant to the courts.
You are required to convene a meeting of the secured creditors, whether online, offline, to ascertain their views on whether this proceeding should be transferred or not.
My lord, I'm sorry, my lord, there is no such provision.
No, we want to know.
No.
We
My
want
lord,
to
there is
know.
no such provision.
No, because one of
Oh,
the
my
secured
lord.
creditors has filed a application.
No, there's no application.
No, in
He has taken a
corporate
point.
Ishmat, there's one, UCO Bank has come up with
Yes.
it.
But in OBG projects, lordship, there is 15 secured creditors, but no one has filed any
Yes,
applications.
there has to be an
In case,
application
lordship.
or someone or secured creditors, unsecured creditors, shareholder. I am giving it, my lord, the widest meaning possible. Someone has to come to court and say, look, we think that it can be revived. Without that, my lord, company court jurisdiction can't be taken away because it has not been taken away.
It's not a question of
We have
jurisdiction being
secured
taken.
Yes,
away.
my lord, that's what's happening.
See, the question of jurisdiction, if there is apparent conflict between the two, because you see, section 7 and 8 of the IBC has a predominant role to play. Once
Yes,
the IBC comes.
yes,
So this is a subsequent legislation.
yes.
2000, I think the ordinance is
2016.
18 is the ordinance.
2016, my lord, is when it got notified. 1st July 2016.
So if the purpose of the two statutes are considered,
Yes,
then, and this amendment of application came
Yes.
much subsequent thereto.
yes,
There was a subsequent amendment.
yes.
So one has to look into that if any person wants it to be transferred. Now, suppose short of transferring it, still the court retain the jurisdiction depending upon the stages at which the company proceeding is pending in the High Court. Still the court will have discretion or not. That's the only point.
Yes, that is my lord. I am saying, my lord, why should the court, my lord, today, my lord,
Because court is,
where the cloak of the litigant. Court is not interested.
the company court is insisting over the company in liquidation
Yes,
to the liquidator.
yes.
So company court is the best judge to decide whether the company court will retain it or having regard to IBC. it should go.
My lord,
So
only
because the company court through the official liquidator is administering the company in liquidation.
my lord, it is administering liquidation. It is exercising jurisdiction in respect of liquidation, which is my lord in terms of the rules, the section and the rules.
Yes, yes.
So my lord,
absolutely.
if someone doesn't come and tell court that please apply your mind as to whether it should go there or not, why should the court my lord be interested really? That is what I'm saying. Because today, my lord, someone has to come and say, I'm interested that the company should go now under the insolvency, my lord, the cloak, my lord, so that it revives. But here, my lord, there's no one like that. And that is why that language, my lord, is very important. Otherwise, my lord, there would have been a complete transfer in the section itself. In the section itself, my lord, it should have been there. My lord, we have, my lord, file, my lord, this we have also now enclosed, my lord, all the judgments in the two matters. And my lord, all those points, my lord, are covered here. Hey, Oh, no, no, no. My lord, the other notes, my lord, can now disregard. Because all this, my lord, that is included. And my lord,
But have you been served by the secure creator of their notes?
no, we have not been. My lord, no one is interested. My lord, these matters, it's now, my lord, really, my lord, the company, my lord, court has to go through the motions, my lord, to finish this matter off. My lord, again, my lord, going and reviving, no one's interested. That's what I'm saying. And the first, my OBG projects, my lord, no one has come.
But still, I will, still I will require the views of the secure traders on this.
In my matter, your lordship, pursuant to the court's order, your lordship, the notices have already been
You are
served.
appearing in two matters.
That is why only you can.
You are appearing in two.
No, one matter, corporate Rishwat, number 6.
Lordship in
That,
Origin
who is,
projects.
how many secure traders are there?
There are many, your lordship, at least 25.
Secure traders.
Only one is before your lordship, that is the UCO Bank.
That is in which matter?
Corporate
Six.
Rishwat, 6.
Therefore, the 6 set order.
In the first matter, my lord, there's in OBG projects, my lord, no one has come.
OB projects, you are there.
Yes, Lordship. There are
total
15
trustee
secured creditors. Lordship, no one has come.
No, that's not a question. Is a stage of disbursement.
No, Lordship. Only claim has been invited. We have received a claim from the
6
secured
and 7. You are 6.
5, 4
4
and
and
5.
5.
4 and 5.
4 and 5.
5 to তোমাদের।
This is what, my lord, we are dealing.
No, first is which matter is appearing first?
My lord, OBG projects, my lord, 4.
OBG you are appearing.
Yes.
Therefore,
Where, my lord, there are no, my lord, no
OBG
one has,
will
my
be
lord, come.
First. Six you are appearing.
Only 6.
4 I am
4 and
appearing.
So 4 and 6 এক order হবে.
Six.
6 এ করবে at least.
My lord.
Oh, revised notes of argument filed
Yes, my lord. We have filed, my lord, in both matters.
on behalf of the appellants.
Yes, my lord.
Are taken, appellant.
লিখে রাখো তাহলে। হ্যাঁ, file today লিখে রাখো। My lord, if the date of today can be put, my lord, then it will be, my lord.
মানে করে দাও তো revised notes of argument. If I
Revised notes.
the revised notes of argument on behalf of the
এটা তো।
These are the notes, my lord.
Notes.
notes you are not required. You are not required.
Grateful, my lord.
দেখা একটা separate file এ করে পাঠিয়ে দিও। হয়ে গেল? না এই ফলটা থাকবে এখানে, এটা আলাদা করে
Lord, item number 5,
yes, all matters are taken
because
together.
there is below, it is at the stage of disbursement.
Yes,
Appellate
we-
side
we
matter.
dispose of all the matters together.
My
My
lord.
lord, my lord, I make,
Yes, yes.
with lordship kindly, my lord, one matter, my lord, I have mentioned the matter, my lord has allowed the mentioning. Now, my lord, we are facing contempt, my lord, what happened? I have been told that the file is not traceable. My lord, this is that matter.
File traceable না। Pending.
Yes, my lord. Contempt proceeding is pending, my lord. And my lord, the court is pressing hard to comply the order, my lord. We have already challenged the
But
order.
you have filed in 2015.
Yes, my lord.
So 7 years you have not done
Yes,
anything.
yes, my lord, that,
We cannot, sorry. If you have not done anything for 7 years, certainly we cannot show any
my
urgency.
lord,
No, you face a contempt. No indulgence, sorry. 7 years you have not done anything.
my lord, very short matter,
Sorry, no, absolutely not. 7 years, state has not shown any interest. Why the court should interest?
my lord, the thing is that, my lord,
Whatever
yes,
the
yes,
thing,
my lord,
7 years you have not moved it.
my lord,
That's the end of the matter.
my lord, there is a change of.
Whatever
plan
is
because
there.
of that.
Change of brief, the client cannot suffer. The litigant cannot suffer for that. Call the list.
I'm getting.
Application item number 105.
Yes. আবার ডেকে যাও দেখি, একটা ফার্স্ট কল করো দেখি, ফার্স্ট কল করো, ফার্স্ট কল করে যাও। Yes, ডেকে যাও, ফার্স্ট কল করো।
106,
I'm for the state.
State, very well.
I have
Yes,
been,
call the list, just this first call, yes,
107,
I'm for the appellate.
yes,
108,
108, I'm petition.
yes,
109,
I am for the appeal.
yes,
110,
I am for the appeal.
you're for the appellant, yes,
111,
yes,
112,
But I am for the state response.
yes,
113, 114 and 15, 116, 117,
170, I'm for the appellate.
yes. ডাকো,
118,
18, I'm for the school authority.
119,
So I am for the appellant.
120,
Malasha, I am for the appellant.
121, 122,
For 122, I am for appellant. I am praying only for not to date. My learned sir, Mr. Dilip Kumar Samant has personal
not to
difficulties.
not to
123, 124,
Lordships, I am for the appellant.
125, 126,
Lordships, I am for the appellant here also.
127, 128, 129, 130, 131, 132, 133,
back. Very well. Yes, 105,
second call item number 105.
straight up. The parties are not represented even in the second call.
Appellant, my lord.
Yes, you have been allowed to join.
No, my lord, I am not getting salary, my lord.
No, you have been allowed to join.
Yes, my lord. I was allowed to join. My lord,
Not
from the,
received-
my
you
lord,
have
from
not
the date of joining, my lord,
No,
my
no,
lord,
you have-
also previous, my lord, during
have-
such.
no, you have not yet received the, you have not yet received your emoluments.
No, my lord. And even, my lord, prior to joining, my lord, during suspension, my lord,
First paragraph কেটে দিতে হবে,
All-
it appears from your The party,
School.
school is a
School is
party.
a-
Yes, yes. Headmaster is a party, my lord. Headmaster is a party, my lord.
No, disciplinary proceeding was recommended against you
Yes, my lord.
for unauthorized absence.
Yes, my lord.
But even if this there, so long the disciplinary proceeding is not initiated, why his emoluments have not been paid?
My lord, papers or all other bills are sending by the school authority to the DI. Then DI,
So they have not sent the papers to you.
no
They have
paper
not.
sent by the school authority.
Take down. Now,
School is,
he has not received emoluments, full stop. The land council representing
assistant headmaster.
there is no headmaster now.
No. My lord, kindly see the last page of the report. Kindly see the last page of the
Of the
report. Last page.
No, but whatever there, if the disciplinary proceeding initiated, he may not give the subsistence allowance.
They are answered by the board.
Yes. You have given the approval. You have not given the approval. So disciplinary proceeding cannot commence.
My lord, I do not have any instruction.
You are appearing the second call, you don't have any instruction. In any event, so long the disciplinary proceeding is not initiated, if it is initiated and if he's kept under suspension, then one thing. If he doesn't, is not kept under suspension, then she is entitled to.
Entitled to get salary, my lord.
My lord,
But-
even he did not get suspension allowance, my lord, during the period of suspension.
Our managing committee, headmaster did not place any bill or any document before the ADI or DI till now.
You have the headmaster or who is for the school.
School is required, my lord. Presence is required.
Right now. They have applied to the ADI office Bongaon and DI office Balashat
Sir.
and board office for the next proceeding. But that has nothing to do with not releasing the amount.
That answer would be from the board.
No, that is with regard to the initiation of the disciplinary proceeding. But that has nothing to do with, because that is a prior permission. Now, I do not know whether prior permission is required or not. Possibly it's not required now.
From the board, my lord. Board is the approval
Now
authority.
it is required, even it's required now.
Approval is required.
Very well. Now, if they have not approved the board, let us put it that way. His emoluments cannot be,
Well, even that, well, I am not resting the remuneration. The school of the raise the bill before the DI or ADI, then release the fund.
they say we apply to the ADI office Bongaon and DI office Balashat. For the next proceeding, not for anything else. কি বললাম? This approval is not there.
My paragraph 2 of the report, my report. Let's see the paragraph
They
2
have
of my,
asked for disciplinary, but no permission was given by the board.
I have nothing.
Yes, you see. You have said they did not take an initiative for appropriate disciplinary proceeding. But the headmaster had written a letter on 3rd July saying that he has not received any approval from the, from them.
Board. Approval is
They
this.
are also there to take instruction.
Koili Bhattacharya.
Where is she?
She's standing at court number 18.
The learned counsel for the board. Three weeks.
Grateful, my
The report filed by the district inspector of school bracket AC North 24 Parganas is taken on record.
grateful, my lord.
Yes,
Well,
next.
My lord, may I beg, my lord, copy of the report, my lord?
Not required. Report is not meant for you.
The lordship, if you also kindly fix a date, my lord, he is not
Three
getting
weeks,
salary
3
year
weeks.
after year.
3 weeks. Yes, next.
Yes. Second call, item number 106.
I'm for the state, my lord.
Six, my lord, I have been requested Mr. Bhaskar Manna appearing for the appellant.
What happened?
He has not come, my lord.
Mohammed Abdullah Ghazi is there,
I told my lord the change.
but power has not been filed. Have you filed? Mr. Manna has filed the power. There is no power. There is no power. Where is the power?
Probably power, my lord, is keep with him.
Then take down. Who is appearing? Mr. Bhaskar
Mr.
Prasad?
Bhaskar Manna.
It is submitted that
One week action, minimum.
yes.
1 week action.
Yes, 107. Ms. Bhattacharya, we have,
107.
we have directed you to obtain instruction. You are not giving permission. Why not? We passed an order. We kept it after 3 weeks. We said all compliance be done in the meantime.
Permission for,
Initiating disciplinary proceeding.
no, my lord, now permission is not required.
But they have written a letter to you, some disciplinary action, I don't know.
No, my lord,
That is the idea. That was my impression also, that permission is not required.
no, now board is the disciplinary authority. Previously,
Then you have not initiated any proceeding. That's just they say.
I'll come back with instruction.
107, I am for the appellant.
My lord, I appear on behalf of the college authorities, my lord. So far as my instruction is concerned, my lord, the state is the answering respondent. But the fact remains I got the informations from the learned GP office that the learned advocate representing the state, particular this matter, she has been depaneled. But kindly, Sipra Mojumdar, she was the junior government advocate, she has been depaneled. But kindly ask my learned friend to make a fresh service upon this learned government.
But upon whom?
I am appearing on behalf of the college authority.
No, upon whom he will serve.
The learned GP, the GP is the competent authority.
But Ms. Shamant was here appearing. She was deputed to this court. Yes, why you are hiding?
What happened, my lord? Yesterday, my lord, one incident took place, my lord. My lord, one matter, Lord, Mr. Chattopadhyay is appearing. Nobody is appearing, including his junior, my lord. I appeared, my lord is directing me to appear. My lord, he is saying some statement. It is insulting me, my lord. I am not begging any brief, my lord. That's why they are not appearing. My lord is directed me to appear. I have not accept this brief. I am praying before your lordship, serve notice to Mr. Chattopadhyay, my lord. My lord was passed this order.
You have been deputed by the government pleader.
My lord, but he is saying some statement. I am not begging any brief. My lord, I am here. Learned government leader requested me to sit here. My lord, that's why I am. My lord, I'm
No, no,
Lord,
he is
kind of-
appearing in this matter.
who is appearing? I don't know.
This is Sipra Mujumdar, I'm told.
My
Sipra
lord,
Mujumdar.
No, she has been depaneled, I am told.
yes.
Now you can appear.
No, Miss Sipra Mujumdar is in the panel, my lord. Panel नहीं? No.
Junior government.
Oh.
Then,
She was a junior government advocate, but now she has been repaneled.
then you can accept it. It's no problem.
Lord, copy may be served, my lord.
You are the fact that the petition along with the Merono appeal shall be served upon Ms. Tramonto. But you must clarify it with the government leader because whom will appoint then?
My
If
lord,
he says
I
it's not appointed.
yesterday I went there, his office, my lord. I have no chance to meet him, and today I will go and inform.
Because then we have go on dismissing it. There is another alternative. Please tell him
I will inform.
that if his state is not represented, henceforth we'll go on dismissing
My
whether
lord.
the state is the appellant and then expiry order against the state recording that no one is appearing.
108.
My lord, I am the petitioner. My lord, by appeal.
Lord, I am appearing for the school authority in this matter.
Yes.
My lord, in this matter, my lord, one application for condonation of delay is there, my lord. There is a delay for 253 days.
Please fill up the blank. Please fill up this blank.
একটু কলমটা দেবেন ভাই। Yes.
এই শোনো,
Thank you.
এটা ডিলেটা কন্ডাক্ট করে দিই।
আমি
Sufficient cause.
No, I am for the school
Yes,
authority.
yes. Don't do this point because your cases will be then absolutely no school is filing an appeal without a condemnation of delay. But we are hearing on merits.
No, this
It's
is
a date of birth.
But this is a
Absolutely not.
school governed by the special rules.
Maybe
I am
maybe
the
special
appointing
rules.
authority.
Special rules. What certificate? He has a forged, he has produced a forged certificate.
So my lord, it is the age dispute.
No. It is recorded that his service was terminated on 11th January 2021. That is what is recorded in the order.
Lordship.
The issue was the date of birth.
Yes,
Now, when he joined, he must have submitted a certificate.
yes.
Now, that certificate, on what basis you are saying it is forged?
But we have verified it. I will use an affidavit to the stay
No,
application.
whatever you say, you show us, because the learned single judge has proceeded without having any affidavit. So you show us that
So I want to use an affidavit showing the documents, my lord.
on what basis this finding is arrived at.
Yes, my lord, we have verified with the issuing authority and we have found that
You have only said that it is a forged document, on the basis of which service was given to him.
yes, my lord.
Show us
Because
the document.
right now it is not with me, my lord. So I want to use an affidavit to the stay application. So kindly grant
Very
me
well.
some time. I'll use an affidavit.
To say on this.
Yes, it is a school of special rules, my lord. I am the answering respondent.
Mr. Shandip Kumar Del and counsel, learned advocate appearing.
I'm grateful.
Courts.
Next.
Just have to date. Yes, sir.
Four weeks, 4 weeks.
Huh? 4 weeks.
Next.
I'm grateful, man.
Hundred and nine. And I am for the appellant petition. Our affidavit of service is there.
Will you appear?
কি আছে দেখি না।
Also.
School has been also, my lord, served regarding, my lord.
My lord, Mr. Vishwabroto Boshu will appearing behalf of the state, but he is engaged on another courtroom number 18, my lord.
I am for secondary board, your lordship.
Page 98.
The state is the answering respondent.
Just a minute.
Planet just passed the order totally on the basis of subsequent notification, which was not in vogue at the time of making the application. Now, may I kindly come to the page 98, the impugned order. Thereafter, I shall make the facts, agitate the fact before your lordship. Wait, no?
My lord,
Internal page 10, 107 running page, finding was there. 29 September 2022 notification was relied on and rejected.
ও কাটে পুরোটাই চলে যায়।
So there is no scope for an interim order.
My lord, subject to correction.
No scope for an
This
interim
order, my lord, shall not stand in the way, impugned order, my lord, because of the fact, I am telling the facts. It does not, my lord, apply to my case itself.
That's an interim order, so you cannot have an interim order. It has to be heard.
My lord,
Not apply to
may
your
I-
case, what does it mean?
just factory. I'm taking your
You
lordship
have to hear, you have to hear
my
the
lord,
matter.
kindly see page 87. Whether the school can stand in the way,
No, there is no scope for an interim order at this stage. It has to be heard.
my lord,
Have you, any affidavit was filed before the trial court?
no. No, on the basis of submission, which is not at all, my lord, germane to the district. Kindly come to page 87 itself.
Yes, but in any event, this matter is required to be heard.
That is
You
to
are,
be.
you are.
And for the secondary board, my lord, state
Then,
is
my
the
lord,
answering
subject
respondent.
to correction.
This is the
My lord,
notification of the state and
my lord, I am praying, kindly fix a date so that it can be, because by virtue of this type of matters, my lord, single bench are my lord, sitting tight over the all these proceedings. That is why my lord, I am praying before your lordship, kindly settle the issue. I am covered by your lordship's own bench judgment. Division bench held, single teacher or my lord, death of teacher is not the ground for my lord, staying the proceedings. If I am, not issue is not res integra at all.
No, but that was not considered by the division, single judge.
Submission was made but did not take
No, no,
consideration.
but those judgments were cited. Which judgment of our
My
division?
lord, I am
judge?
placing your lordship on.
Which judgment is to this?
That is in case of Amar Kumar Jana. Your lordship kindly sees this. I have made a compilation. There are other honorable division bench.
No, but that was not cited.
No, it was cited, but it was not taken into consideration.
No, but
Anyhow, my lord, I am not disputing on this. It's pat on the point. They are also case managing committee, my lord, raised objection to issue no objection. Here, managing committee has given. Subsequently, my lord, turned back. Approbate and reprobate doctrine of election is applicable to my case. That is why I am placing page 87. Managing committee forwarded to the DI. DI said single teacher. Your lordship's observation is single teacher or dearth of teacher is not the ground for rejection because rule is in my favor. And Ranjit has totally, my lord, misdirected on the ground of 10C. 10C is not my case. My case is 10B. In the impugned order itself, it has been quoted out of 10C. And PTR is not the issue before the trial court. Pupil teacher ratio, gazetted notification, 22nd of September. That is not the impugned order of the authority rejection. Only 10%, that is not applicable. Single teacher is not applicable. Now, my lord, petitioner is suffering because of the fact that she is the, my lord, departed wife, as well as 77 years of father, mother died, wants to come back at Damdam where father resides. Same issue. My case is better than that case. Your lordship dealt with it. And next honorable division bench also on the same tune, single teacher. So issue is not disintegrated before this honorable bench. And that is why, my lord, I am, my lord, so, my lord, so that
the single bench as my lord sitting not to take up this type of matters. A galore of my lord teachers are,
No, that time we heard Dr. Patro
yes,
and
issue is the same. Now, government issued a notification. If your lordship kindly come to the notification itself, page 82, I believe. 80. But kindly see page 80. Government issued a notification to that effect the single teacher is not the bar. And your lordship's view is totally uh, subsequently it has been adopted by the state legislature, page 80, by way of amendment. It should not have been rejected. And that too, managing committee cannot take the hot and cold. Page, kindly come to page 87. Managing committee by a resolution given the no objection. Subsequently, that managing committee turn around and says 10%. Whether that can be, I have the judgment of Supreme Court also to that effect, approbate and reprobate. Page 80 kindly, 80 and 82, 10% also relaxed. And your lordship's view is this: after transfer, it will be filled up by subsequent appointment within certain period. There are other honorable.
West Bengal Central School Service Commission is a party here.
Yes, party here. I have served also.
Who is appearing?
Mr. Mitra is appearing. Saurabh Mitra is appearing. I had the talk yesterday. That matter will be taken up today, your lordship. Page 80 and 82 is the government circular notification itself by way of official gazette. Relaxation has been made to that effect. So I am entitled.
In this matter,
Yes.
this judgment you have cited,
Yes.
you are considering the General Transfer Relocation Rules 2015.
15, and that is the amendment.
Just a minute.
Yes.
Here, it has to be considered by the subsequent notification.
Notification amendment I have annexed.
Yes.
Kindly come to that amendment of 2015, that is page 69. 69 also my lord given some relaxation.
So
Page 69.
No, these two rules we have not considered.
No, not that, but
After
it is the
amendment, we have not
amendment.
considered.
We are in better case, in the better sense.
Where are the transfer rules?
Yes, transfer rules 2015 I am giving. Initial 15 transfer rules, my lord. This is the 15 transfer rules. Kindly take.
Will it not be here?
Yes, in the book also. Then I'm searching. Your lordship, kindly go through these rules. I am searching. বইটা দিন তো ম্যানুয়ালটা দিন আমি বার করব।
ওইগুলো কি হলো এখানে ভলিউম 1 ভলিউম 2 গুছিয়ে রাখছো না গুছিয়ে রাখো এখানে।
Yes, it will be there.
উঠে যাওয়ার পরে কি তোমাদের এগুলো গুছিয়ে রাখার দায়িত্ব নেই নাকি? say about the
But
interpretation?
I'm giving this to him.
Of course, this was delivered in 2020. Thereafter, two amendments are there. But whether those two amendments substantially alter our judgment or not, that is the point.
Yes.
And also, my lord, your lordship kindly consider, though it was the answerable respondent is state mainly.
No, but commission has
Yes, yes,
answered this
yes,
also.
yes. My lord, our view is, my lord, in certain points, because it's a case of transfer. It's not an appointment, not a pay scale. My lord, the clock cannot be, my lord, now switch over because entire things has been done. According to that particular portal, Utsosri portal, almost 19,000 teaching and non-teaching staff has exercised successfully. Well, those who agreed, they have come before the court. We have complied. But now what happens, this all the teaching and non-teaching staff, they are rushing towards the urban area. That is why we stopped. That is the situation that has been, that is
No, but-
considered by the learned single bench.
No, but still then, if there are genuine cases of transfer,
Yes,
this has to be considered.
no, my lord, now the portal is totally stopped. It has been suspended now.
Suspended in terms of the order of this court.
Yeah, not only that, we have,
Well, maybe stopped, but their right to get transfer has not been taken away.
no, my lord,
This-
no, my lord,
Because this budget notification of whether you call it 2020 or earlier.
it can be only done, my lord, online. Offline mode, my lord, it's not permitted. Unless there is
Very
an
well, what is the difficulty in considering his application online for the purpose?
online
He has
portal.
already, it's not a case that he has not applied. That portal may have stopped. But he made an application. That application is required to be considered on the basis of the your transfer rules. That you require to consider.
Now, my lord, so far that part is concerned, my lord. Now that portal, lordship has,
You forget about the portal.
well, unless and until that has been opened, my lord, how we enter into?
No, question is this. If the portal goes, these rules are there for transfer. So if you say through that portal is not possible, then these rules are not abrogated. These rules are not depending upon the portal being operative or not.
Much obliged.
No, now, my lord, the question is, my lord, with
You make a system unworkable, but that
No,
doesn't
it
mean
has been
that doesn't mean the rules will abolish.
no, my lord.
The
the-
rules are not abolished. It has been, for the
it is
time
there,
being,
my
it
lord.
has been
It is
suspended.
everything is,
Well,
everything is, my lord,
transfer
for
is
the
not a
time being.
that kind of right, my lord. It has to be exercised now.
Now, my lord, what
My lord,
happened, my lord?
May I
We have,
submit?
we have transfer applications are concerned, my lord. There are, my lord,
No, you
Tra-
consider if you filed what was the reason for which it was not allowed? What was the reason?
That is
Kindly
already in the
see, it is
portal.
not, it is not subject to
It is
correction.
already in
Kindly
the
come
portal.
to
A
page
portal is
91.
showing.
Kindly come to page 91, their notification, it is not suspended.
No. What is the reason for denying your
Yes, that
transfer?
is
My,
already
my
there.
application,
Yes,
denial,
Yes.
only on the basis of single teacher.
yes,
yes.
that is the
Well,
reason.
no.
If the
And now,
school
lordship,
doesn't have
now
a teacher.
if you,
No,
now
no.
we have come up with a policy, my lord, with regard to rationalization. Now, if suppose lordship a Bengali, one teacher,
Yes.
and the school, 1, 3, 4 teachers. So
See,
can we transfer that teacher?
Similar point came up, and in fact, these rules that we have in place, that also provides, gives an answer to this. When it says,
Page, my lord?
Local arrangement to be made.
first you say,
Yes.
yes, first you see page 70. While considering such application E, if resultant vacancy of the school in particular subject becomes 0 or not commensurate with role strength, SMNC shall approach the CCSC through DISI for filling a vacancy.
Lordship. Now, my lord,
And this was also the view in Amor Jana after we heard Dr. Patra on this.
but my lord, now, my lord, after that, my lord, another notification comes, my lord, with regard to this transfer policy. That says, my lord, that government has now introduced with a rationalization policy wherein, my lord, the teachers can be transferred from one place to another subject to PTR, the pupil teacher ratio. Now, my lord, what
So
happened?
why don't you consider this matter afresh in terms of our order in Amor Jana? And if you find that, see, single teacher cannot be a sole ground if he is able to make out other grounds.
No,
Suppose if he conforms to A to E, then automatic, single teacher will be a ground.
Then, my lord, in that
He has
event,
to approach afresh.
in that event, my lord, then how he made application?
He made an application at that point of time.
My lord, so the problem
He
is,
made an
my lord,
application at that point of time.
lordship.
Your rules must override any other technical snag you may have.
No, subsequently thereafter, my lord, another rule comes, my lord, that what I have
No, no,
stated.
whatever
lordship.
rule has come, he made an application, his application is required to be considered on the date he made his application.
Lordship.
Whether he was eligible for transfer on that date or
No,
not.
my lord, that has been rejected on the ground, my lord, that single
Single
teacher.
teacher.
Lordship.
But that is not the, that is a wrong reasoning because of our Amorjana's judgment.
Absolutely.
And also the proviso provided in your,
Subsequent
there's a clear
amendment.
proviso is your rule. We are
Lordship.
showing you your rule, not our rules.
No, I'm
Then-
not disputing that, my lord. The only things is that subsequently thereafter,
Consider this, consider this because if she has a genuine risk, we are not going into the whether,
Lordship.
even if you to consider him to be a single, but still you can deny it provided other grounds are not satisfied.
Lordship. Lordship. Now, because
You
since, my
consider
lord,
you go through this judgment in Amorjana,
Lordship.
both of you,
Lordship.
come back with the suggestion, we dispose of the appeal accordingly.
Let my learned friend also satisfy because this Amorjana's
Amorjana.
case has been decided in 22nd December 2020.
Exactly.
Not, my lord, the moment of time when this was happened. My lord, we have to, my lord, move pragmatically.
No. Of course, we are not saying that
Like
you set the
after-
clock black. We are not saying this.
Yes.
But even after the amendments have been carried out to the rules,
Yes,
this element remains because your rule itself says so.
my lord.
Beneficial to the teachers.
Now, my lord, another things happen. There are other two division bench also we have to obey. Because in our presiding over by Honorable Chief Justice and it was held that people teacher ratio of the, my lord, the school where the petitioner seeks for transfer is the prime consideration, should be. That is a division bench
But
judgment,
if he found to be there where he's sought to be transferred,
not sought to be, where he is working, she is working now.
where she is working, suppose it result in, first of all, in her case,
Yes.
there are two teachers. So resultant vacancy will not be zero.
Yes,
Resultant vacancy is
Yes.
not zero.
Yes.
Now, if the resultant vacancy is not zero, then you may require another teacher.
yes,
If he satisfies any of the criteria A to E, then proviso gives you an answer.
yes. 4E.
My lord, kindly come.
My lord,
We are not saying anything devotes the
my lord,
rules.
my lord, I understand, but our problem is that, my lord,
That is why everyone will have
no,
problems,
my lord,
but we need a
what
solution.
is the problem? That is also, my lord, scarring to us because people teacher ratio
No,
is
that is why you have to consider, you see, there cannot be a straight jacket formula. It has to be considered. Someone may have suppose she made out a ground for A.
Yes.
Can you say people ratio, we are not releasing you?
She is not barred for making further applications.
No. She has a right.
Yes.
If he conforms
Right
because
for
your
application is always
because
there.
your rules permit it.
Yes.
Now,
That I am
he
not
doesn't
denying.
come within A to C or D, but he comes, he said any other reason.
Any other,
So any other reason, you denied it because of the people teacher ratio.
my lord.
Fine. Now, people teacher ratio, if it is resultant is zero, then it also
Not-
provides.
It has to be 40, my lord. PTR should be 40.
Here
That is the central government, my lord.
the resultant effect is not zero.
No, we have to check out.
But the teacher, my lord, the refusal is single teacher.
That is why he says single teacher, but he said there are two teachers on this.
But my lord, if suppose, my lord,
And if there is a
1,000.
single teacher, then also the proviso comes, provided she is able to make out a ground for her
Now, my
transfer.
lord, that is the reason,
lord,
my lord, that is the reason the new latest the circular has come, my lord, to, my lord, cut short this entire issue because there should not be any less teacher in a school.
Yes.
No one wants a less teacher in a school. But when he made an application, the ground on which his claim was denied was not correct. It's contrary to the principle, contrary to Jana's
Amorjana.
case.
That is the correct, my lord, kindly
Now,
come.
my lord, thereafter, as pointed out by Mr. Mitra, my lord, the Chief Justice has passed an order with regard to this issue, wherein it has been specifically mentioned that PTR should be maintained. My lord, that's the whole problem now, my lord.
PTR should be.
If that be the so, my
That
lord.
is not in conflict with this.
Yes,
judgment.
my lord.
Purely conflict. Why,
If that be the so, my lord, then my lord, if the single
Then
teacher,
then the notification becomes ocious,
Yes.
proviso becomes ocious,
Yes.
proviso becomes ocious.
no, not in that sense, my lord.
But every case has to be decided on its particular fact.
Yes, my lord, definitely.
So if he is make out, you see, that judgment, whatever the chief justice may have
Lordship.
delivered, as you
I
say,
shall.
we have not gone.
Yes,
through.
yes,
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 it has to be rationalized. No one can
No,
dispute with that.
why that has been,
Question is this: what we are saying. We are saying in terms of your own rules. We are not saying supplementing or supplying anything to the existing rule. So it's a delegated legislation. So when these rules are being made, they are conscious of the fact that it might result in a zero vacancy.
Well.
But still, the teacher may have a genuine case. Then what would happen?
Yes.
So maybe you may not release her or him so long you are in a position to recruit. That is understandable. But that process has to start.
yes.
That
I
is the only thing.
I understand.
My lord, kindly come to page.
So we are here for a solution, Mr.
So, my lord,
And my lord,
So,
we are
what is the
also, my lord,
solution?
two
helpless.
things. My lord,
Only
Give
thing,
me some time, my lord, let me come
But-
back before his
yes.
lordship with specific
Think
insight.
of-
Lordship,
My
can
lord,
you
my lord.
indicate that in that order.
my lord,
Lordship.
kindly, my lord, 2 pages. My lord, I am showing the two.
না, 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 একটু solution just.
না, না, আমি তা বলছি না। Only for the rule,
The-
subsequent rule also.
the denial of the transfer on the ground that where is the
Page 87. That is why man, I am pressing this.
page 87?
Page 87, kindly sees
কি বললাম?
right column.
Just a minute, just a
Yes,
minute.
yes.
So denial of the transfer. Sorry.
87 got it, my lord? 87 of the application.
The denial of the ground.
Right hand side.
Denial of transfer on the ground.
Managing committee satisfied. Page 87. As per managing committee, why such and such
No,
resolution.
just you want to find out the reason.
This is the final, thereafter due to back DI from HY due to single teacher. That is the only observation.
Due to
Single teacher, top,
why
right hand side.
আচ্ছা, yes. কি বললাম?
And subsequently,
Just a minute.
yes.
Denial of on the ground of single teacher by the DI.
By the DI, return back.
Uh,
Managing committee satisfied.
may not be in conformity with
should be from 40.
1:60.
No, you see the,
That has been in the order.
see, when the MC has recommended,
Yes.
so MC must have taken into consideration.
I don't think so, my
My
lord.
lord, that is why
I
the
don't think so.
No,
That's why, my lord, this, everything has been, because in the
No,
order it
because-
has been mentioned, that student of that, in that school is, my lord, 1502. And teacher is only 25, where it should be 42.
No, that's a different issue, but
That is the issue involved in this case.
Order.
the affidavit service.
Get rid of it.
Sure.
Much obliged. Weeks. No, no, about
Yes, call the list.
110.
So I am for the state in this matter.
But I am for the appellant.
Yes, yes. What is this matter? What is this matter?
Appellant is the my lord trained candidate prior to my lord 2013. He appeared my lord paid examination for recruitment of assistant teacher in primary school. My lord, his result was not published. He filed and read petition in the year 2017.
Now, where is the report? Report is here.
Yes.
No, direction has been given to
Yes, there is a direction for filing a report on 13 June.
My lord, what happened, my lord? My lord, his application for my lord TED examination, my lord, against the my lord his application, my lord, roll number was allotted by the recruitment board. My lord, he in his application he mentioned that he is a Bengali medium student, but board state that in the OMR sheet he does not mention the medium. For that reason, my lord, his answer sheet was not
Evaluated.
evaluated.
Have you
What are-
seen the report?
Yes, my lord.
Yes. What does the report says? Yes, please take your seat. Let us go through the report. এই শোনো না, এদিকে পাহাড়ে চালাতে বড় গরম লাগছে। এদিকে একটা। No, you participate in the interview.
No, my lord. My
Okay.
case is that, my lord, if the my lord TED result was published in the year 2000, my lord, 15, then my lord he should apply for in the 2016 recruitment. My lord, what happened 2016 recruitment? All the trained candidate who have my lord qualified TED, all have got appointment. Petitioner claim is
No,
that, my lord.
According to the report,
Yes, my lord.
you secured 104
Yes, my lord.
out of 150 marks.
Yes.
In TET 2014,
Yes.
and you were declared TET 2014 qualified.
Yes.
You participated in the recruitment process
2020.
of 2022.
Yes.
Why 2022?
But I tell your lordship,
Why?
my lord, initially, petitioner appeared in the TET 2014. My lord, in the OMR sheet, he did not mention his medium of code. Therefore, the OMR sheet was not evaluated. My lord, he filed one writ petition. Before this honorable court,
No, but he was found to be TET qualified.
my lord, when? My lord, I'm asking myself,
Yes,
your lordship,
when?
my lord, kindly see, my lord.
Tell us when.
My lord, he was declared 2022
Why?
because his OMR sheet was not evaluated because of his mistake, not the mistake of the authority, my lord. His mistake. My lord, he has admitted in the all where, my lord, in the
Wait.
paragraph 15, your lordship,
When he was declared TET 24 qualified, when?
2022.
after he filed the writ petition.
My lord, his OMR sheet was not evaluated. My lord, the court directed you evaluate the OMR sheet manually. My lord, when we manually evaluated the OMR sheet, he declared pass 2022. My lord, then my lord, 20 recruitment process and 16 recruitment process was over. My lord, he was allowed to participate in the 2022 recruitment process. My lord, he has admitted his guilt. My lord, he has admitted in paragraph 15 in the order passed by the single judge.
Yes.
My lord, both the order and my lord, paragraph 15 in the writ petition also, that it was his bona fide mistake.
My lord, when the my lord application was filed for my lord TET examination, he mentioned that he is the Bengali medium, and accordingly my lord roll number has allotted. My lord, if the my lord OMR sheet there is a my lord not mentioned, but his roll number is allotted in the Bengali medium. So my lord, how he can stand that my lord OMR sheet he does not mention, so his result will not be published.
State examination, are you required to subject-wise state held? Is there any provision for having a TET is eligibility test?
My lord, your lordship
Yes.
kindly, my lord,
Then the
comes to one
eligibility
report. Your lordship have handed over the report. Your lordship kindly, my lord, come to the page 6. This is the my lord digitalized data of the OMR sheet.
Yes.
But here is a column, the medium of instruction. Your lordship will find.
No, but
My
the
lord,
delay was at your end.
my lord,
The delay was at your end.
my lord, kindly, my lord, appreciate.
No, what we
My
will
lord,
appreciate.
subject to correction, no.
There is a, no, yes. Read the order of Justice Gangopadhyay.
My lord, your
Please
lordship,
read the order
kindly,
of
my lord,
Justice
before
Gangopadhyay.
that, I will, my lord, invite, my lord,
Come before, please read the order of Justice Gangopadhyay.
my lord.
He was declared petitioner as a successful candidate TET 2014.
Yes.
When he was declared successful in 2014.
My lord, successful candidate, TET 14, my lord, in the year 2022.
Why?
My lord, that is, my lord, I am trying to, my lord, submit. Your lordship kindly, my lord,
No, no,
come to
see,
page
see, see,
41.
I think you may not be correct. Consequently, he was allowed to fill up the form for the ensuing recruitment test,
Yes,
which he has done, and now there is no other grievance which is required to be adjudicated. Then,
my lord.
though the petitioner has submitted that as he has been declared as a qualified TET 2014, he should be considered as a candidate in 2016. Recruitment process, as there was an order passed by this court on 11 January 2018, where this court directed the secretary of the board to consider the case. So from 2018 till 2022, he did not consider.
My lord, my lord, I am coming. Your lordship, before that, your lordship kindly come to page 41. This is the order passed by the, my lord, honorable single bench. My lord, the earlier writ petition. Page 41. My lord, may I read the order, my lord? Page 41, my lord, 6 line from the bottom.
There's a problem for you.
No, my lord,
And
he-
your
my-
lordship,
my
paragraph.
lord,
Because
there-
the panel 2016, you cannot be considered, but that panel is over. How in 2022 you can be accommodated? How? You
my lord,
cannot
because
be.
because my
My
lord,
lord,
mistake
2022
by
he
the
is
no, no,
accommodated.
because of mistake by the board.
No,
My lord,
you
when
yourself admit it's not that. Unfortunately, in the OMR sheet, he failed to put tick mark against Bengali as medium under column 4, medium of instruction.
yes,
So it is an incomplete form.
no, my lord, that not.
It is an
The
incomplete
rules
form.
does not show, no notification does not show there is incomplete. There is no.
No.
My lord,
Forget about it. It is not a complete form. You have to fill in the all the details.
my lord, they have evaluated the OMR sheet against the roll number. When my application I filled up, I have mentioned I am Bengali medium. That records is the board, and accordingly, my lord, the roll number was
this
allotted.
examination was held purely for Bengali only.
Most of them,
Medium, Hindi
most-
medium,
that are,
Shantan,
that
all the
other
medium.
media,
No,
other
if
medium
you are-
candidates are,
See,
not,
your admit card may be Bengali for
Yes.
Bengali and other documents Bengali.
yes,
But when you are supposed to fill up the WMR form,
yes.
then you are supposed to fill up all the necessary details.
Exactly.
Otherwise, you would not be allowed to sit. We do not allow anyone to sit for that if it is incomplete form. Rather, we ask them to rectify it. We give a time to rectification. I do not know whether board has any such procedure. So admittedly, you made a mistake.
That's true, but my lord.
But if you made, see,
Yes.
difficult is this, if you made a mistake, we cannot put the clock back because in 2016, that entire thing is over. Even when you file the read, by that time, the panel was completely exhausted. Where you will be fitting?
No, my lord, when the, my lord, first read petition was, to then panel,
It's
panel
11
was like
January and you see the
2017.
report, and you see the report filed by the board. This panel was,
My lord, even after, my lord, by the order of this code, my lord, 2000, my lord, 22 and 23, my lord, they have got appointment in connection with the 2016 panel.
is there any
Malad,
appointment?
20 No, Malad 2022 recruitment process is going on. He was allowed to participate in the 2022 recruitment process.
Very well.
Malad, he participated.
Then,
Malad, the result was not yet published. Malad, the
then
panel
if
was
he
not.
is successful, then
Malad, if he is successful, Malad, his name will be, Malad, the panel will be published and he will be given a
only
recommendation.
the life of the 2016 panel expired according to this report on 23rd September 2019.
19.
So by that time, the order of the Justice Strategy had come.
Malad,
By that time, the order of Justice Strategy had come.
Malad, your lordship kindly see, Malad, order of
So
the
in
Justice
2000
Strategy was
yes.
considered. Malad, both passed the rescind order.
Listen to us. This order of Justice Strategy is 11 January 2018.
Malad,
So still then the panel was not complete. The life of the
Yes.
panel was alive.
Malad,
Yes.
So, so by this reason of this order, you were supposed to consider this.
Malad.
You kept it pending for 4 years.
No,
Yes.
Malad,
Yes.
the
What,
order.
no, you kept it pending for 4 years or not?
No, Malad, your lordship kindly, Malad, appreciate one thing, Malad.
We are not being able to appreciate this. You
Malad.
kept it pending for 4 years. Why? Otherwise, if this application was considered, then in 2019, you could have been accommodated because the panel, according to your own showing, it was valid up to 23rd September 2019.
Malad.
Then
Malad, as per the order of Justice Strategy, Malad, the Honorable Justice Strategy, Malad, the prayer of his Malad, the evaluation was rejected. Because Malad,
No.
your lordship
Was
kindly appreciate,
No.
10 lakhs candidate appeared, Malad, none
you are
of
not
the.
answering. You are not answering our
Malad,
question.
I'm coming,
You are
Malad.
beating around the bush. You answer our question.
Malad.
When this order was passed by Justice Strategy,
The order of consideration
yes,
was
so
passed.
So consideration you rejected because the panel, because now you are showing why you cannot accommodate him because the panel had expired.
Malad, these order, Malad, he was qualified till 2014 pursuant to the order of this honorable court. Malad, not by the order of Justice Strategy.
He ought to
Subsequent
have-
order.
No, that is why I was saying that this 2018 representation, you kept it pending for 4 years. When you decided it? When you decided it, tell us.
Malad, 2022.
Why?
Malad,
Why you should? And you taking the plea now that the panel had expired.
Not Malad, not the
I will
plea.
send this person to jail. What is going on? If he was considered, then his appointment ought to have been made. And you kept it pending at your sweet will, accommodating persons who are according to your own choice and whims.
Malad, 2016 recruitment process. Your lordship kindly, Malad.
2016 recruitment process was valid up to 23rd September 2019, according to your own showing.
My lord.
So by that time, he was qualified. Why case was not considered? Now you show him the door.
My lord, at that point of time, your lordship kindly appreciate, at that point of time also, my lord, none of the candidates were evaluated, those who have not marked, my lord, the
By reason of
instruction
this
of,
order that
my
was
lord, these-
rectified.
my lord, your lordship,
By reason of this order, who has come or not is absolutely immaterial.
My
He
lord.
came, Mr. Badi admit that I have not done, please allow me.
My
So
lord.
that is what the thing is.
my
This.
lord, your lordship kindly, my lord, come to, my lord, my lord, the order of justice, Chattopadhyay once again, my lord,
Yes.
your lordship kindly, my lord,
Yes, absolutely.
my lord.
Mr.
apart
Badi
from the, my
submits
lord,
that by
page
mistake it
41,
was not done.
my lord,
So I would have followed, you would have followed that out by 11 January 2018,
my lord,
the panel was exhausted.
my lord,
But when your panel was alive till 23rd September 2019,
my lord.
And it is an admitted position that he has not put the tick mark in Bengali. So this needs to be, this by reason of this order, it stands rectified. Now you have to consider whether he should be, his candidature should be.
One thing is troubling, your lordship, kindly appreciate. My lord, entire OMR sheet is evaluated by the machine, not by the manually. Unless, my lord, we are directed by this honorable court that the evaluation has to be done manually, my lord, both cannot do, because 10 lakhs candidate appeared in the 2016, 2014 TET. My lord, it is not possible for the, my lord, authority to, my lord, evaluate all the, my lord, answers sheet manually. My lord, pursuant to the order of Justice Gangopadhyay, his OMR sheet was, my lord,
Are you
evaluated
serious about,
manually.
are you serious about your submission? Are you really serious about what you are saying?
My lord, what is,
See the order of Justice 11, Justice Strategy on 11 January 2018.
my lord? My lord.
Read for yourself what it says.
The petitioner filed the present writ petition for the direction upon the respondent authorities, particularly the President West Bengal Board of Primary Education, to consider the petitioner representation dated 22nd March 2017. Mr. Badi submits that though the petitioner in its admit card and other document mentioned Bengali as medium, but unfortunately OMR sheet he failed to put tick mark against the Bengali as medium under column 4. Therefore, the petitioner's candidature was not considered, hence the present writ petition. Therefore, Mr. Badi submit that the respondent authority may be directed to consider the representation's bona fide mistake to mark against Bengali as medium, though he filled up all the documents regarding medium as Bengali in OMR sheet. Mr. Biswa submits that unfortunately at this stage petitioner's prayer for consideration could not be done. The submission of Mr. Biswas was endorsed by Mr. Chattopadhyay, learned advocate for the state. Considering the submission of the learned advocate for the parties, and after perusing the records, I direct the respondent number 4, Secretary West Bengal Board of Primary Education, to treat the petitioner to treat the present writ petition as the petitioner's representation and take a decision within 6 weeks from the date of communication of this order, after giving an opportunity.
So was the decision. So was the decision.
My lord, I have to take, my lord.
have
Whether the
taken
decision
instruction.
was, my lord, only, my lord, he has annexed the, my lord, hearing, the notice of hearing.
What is the decision you have taken pursuant this? What is the decision?
I got your lordship. What is following from your lordship? I have
So
got it.
if it were to be considered within 6 weeks
My lord.
as directed,
My lord.
and it was what the learned judge has said, that's a bona fide mistake that is required to be considered.
My lord.
So if he says, if other record shows Bengali to which he has applied or documents he has produced, then this is obvious mistake, it is only a rectification. If it were rectified within 6 months from that date, then he would have been, the panel was valid, he could have been accommodated.
My lord, predicament is one, my lord. My lord,
There is
I
no
could not, my lord, I could
Predicament
not,
you have
my lord,
created for yourself.
clear myself, my lord.
You have created for yourself the predicament.
No, predicament is that, my lord, OMR sheet once. OMR sheet was evaluated by the machine, my lord, but not the
You
manual.
have been given 6 weeks time.
My lord.
6 weeks time with this, you should have whatever, if the machine has not, the machine has to be corrected, that particular entry that is required to be done.
My lord, it is not possible by the machine. It was evaluated by manually after
Correct,
order of this
correct.
court.
So order of the court was 2018. So if this was corrected manually, we are thankful that you have understood this problem.
Okay.
Then within this six weeks time, this tick mark, this correction.
I got
So-
your lordship, my lord.
So
Your
you
lordship,
would have been accommodated.
my lord, your lordship, kindly take
You
it.
would have been accommodated.
Monday, my lord, let me, my lord, come with your lordship. I've got your lordship.
You have
my
to
lord.
find a solution.
My lord, for his own mistake, my lord, he was participated in the, my lord, 2022, my
It
lord,
is your
recruitment
mistake
process.
as well. It was your mistake as well. It's a contempt, in fact, by not considering it.
My lord, then after, my lord, the writ petition,
down.
my lord, the order was passed.
Take down. The report filed by the West Bengal Board of Primary Education
not mark any of the option, his waymarks will be treated as invalid. I will show your
No,
lordship.
you should have declared it invalid, no
My lord,
problem.
I'll show your lordship, my lord.
You should have declared it
If
invalid.
your lordship cannot assume, my lord, for the sake of argument, that we have not declared, but it is deemed, my lord, he has my lord, the invalid waymarkship.
When this six weeks time was given to you,
My lord,
you should have, because that panel was alive till 2019.
my lord.
You did
My
not.
lord, automatically deemed to be, my lord, invalid the OMR sheet.
This is an order passed by the court allowing rectification. And you have manually done it. What you have done in 2022, you should have done it 2016 or 2017 or
My lord,
2018.
2022, we have done it because of the order of Justice Gangopadhyay. My lord, another order.
In 2018, again we repeat, in 2018, if you have done it, then he would have figured in the panel of which was alive till 2019.
State candidate melody.
My lord, 2018, we
Must
did
be.
not do it. We did not do it.
So if you have,
Because my lord, all the candidates were treated as invalid because he was not given, my lord, option of instruction. medium of instruction.
whoever has come to court or not, we are not concerned. He has
Hello.
come to court
My lord.
and court said that this is a bona
My
fide
lord, board
mistake.
ought to have passed the rescind order, my lord, within 6 weeks.
No. Either they declare is invalid,
My lord, that's
either declare invalid, or in terms of this direction, allowed him to put a tick mark. Now,
that is not possible, but otherwise, my lord, the board ought to have taken the, my lord, decision, my lord. Or my lord should have declared the invalid, my lord, at within 6 weeks. My lord, that's, my lord, I have, my lord.
so if that was removed, if it was, now you are allowing this. You should have said before Justice
My lord, he's automatically
No,
be
you
allowed.
should have said just before Justice Gangopadhyay
Right.
that is invalid. So we cannot consider it. We may consider it for the fresh recruitment process.
My lord, we have considered him a first recruitment process.
You should have told before Justice Gangopadhyay that yes, at that time it was invalid. So it is being considered for 2022. You have not said so. Don't do a pick and choose policy. Yes, next matter.
Developed.
Item number 111.
No, sir, I am for the state in this matter.
Saying only not to.
Why?
The Prosenjit Mukherjee, this matter appearing engaged to court number 19.
Not today. Next.
No, not today, not this week. Lord.
Not this week. Next.
112.
I beg to appear on behalf of the appellant.
Yes.
My lord, today is, my lord, there is a direction passed by my lord, the Justice Taluk, the division is Talukdar, my lord. Today is supposed to file a report. Whether, my lord, is the grievance, my lord, the certain report of the state, from the state, my lord, Mr. Prasad is appearing on behalf of Abhishek Prasad. He was, my lord, the outside of the court. So, my lord, this is the case, my lord, the petitioner before
Just a
you.
minute.
No. So, question.
Just switching over.
Switching over, my lord, he continued, he submitted an option. But then, in spite of that, he continued, my lord, to deposit his share, employer continued to deposit his share, and it went on till his retirement. After retirement,
Although he exercised his option.
yes, all the exercise option, and but he continued not to be a member of the contributory provident fund, and he continued to deposit amount, and even after retirement, he specifically asked for refund of the employers and employee share.
That he has not refunded.
Entirely, he has got everything. He has
But
got.
he has not refunded.
He has not refunded a single penny. Now, after the 2013 special bench judgment, he was again asked, my lord, to exercise his option, even though he had taken the entire money and retired long back. He was again given the option. He did not comply.
He was again given the option.
Again given the option.
My lord, may I submit on this? My lord, one submission before your lordship. If they can show any crap of document that after retirement, I have, my lord, received the entire CPF, I have no case.
My lord,
Second submission before your lordship.
I had produced
As per
entire
the, my lord,
records.
this entire record, my lord, my lord, this the rule says, my lord, I have, my lord, the submitted the option within time. They have accepted, that is their duty to discontinue my CPF amount. That is the rule says. That is the special bench judgment also, my lord. Ibrahim Mollik judgment, the division bench. So I have no duty because of that. It is on the fault on the part of the school authority as well as the, my lord, the authority concerned, that the pension sanctioning authority. My lord, I have come with the, my lord, the short list of dates. It will be helpful by, because of that. I categorically stated that after retirement, I have not received any money from the, my lord, the school authority. Before that, I accepted or I have taken the loan from my own account, that is my PF account. So now there, my lord, the document which has been showing, my lord, all documents are before retirement.
No, but if you have exercised the option, then you should have refunded the amount.
That is what, where is the calculation? They have not shown. My lord, that is the special bench judgment also shows. My lord, straight away I will deposit the said amount. Their calculation has to be, my lord,
You
submitted.
ask for the refund.
Why? No letter.
Mr. Gupta, did you ask for the refund?
I asked him to exercise the option, but
Once he exercised the option, his duty is
no,
over.
he continued, my lord, there are 43 teaching staff in the school. My lord, except 2 or 3, everybody, my lord, discontinued CPF. But only me, I showed the,
No, Mr. Gupta, the thing is this, once he exercises his option, it is a school's
he
duty.
doesn't act on the basis of it.
No, but if he has offer, you have required to accept. Once you accept that he said, I don't want to switch off. So after the switching off is there, then the ball is in your court. Then you have to recalculate, find
Yes,
out
but-
what would be the contribution.
But my Provident Fund records will show that in respect of all the teachers, my lord, money was never deducted on account of Provident Fund because they exercised option and went by it. Only in regard to them, only in regard to him and another teacher, my lord, they asked for continuance of this. My lord, you'll still find that he asked
Then
for,
in writing that he asked for, because one the option is
yes,
exercised, then he loses right. Go
no,
back to the,
once he exercised the option, he has to go by that.
yes,
My lord, he has to make a refund of the money.
once he exercises option on that date. So also on that date when he's switching over, then it will be prospectively, whatever he has given, he has given. If he is required to refund any amount already recovered, then you have to say that you refund this amount and we will continue
My
with
lord,
that.
if the district inspectors asked for papers from us, we sent all the papers to
But
the
then
district
how
inspector.
he's responsible. And he still then says, I'm willing to let them say what is the amount. I'll
But
refund it.
he's now 87 years old. He has enjoyed the money, entire money, the employer's contribution, etc. for all these years. Now, my lord, at the age of 87, he says, I want to go to the pension.
My lord, they have.
File this petition when?
No, but he continued to maintain this stand when he exercised his option.
My lord, he knew that this was not done in his case for whatever reason. Because for everybody else, my lord, this is
So he has to
discontinued.
refund it with interest, as simple as that.
Yes.
If he wants, he
That
refund it
means-
with interest.
We refund with interest, my lord. Is there any time left to do that? Even after special bench judgment, which granted 3 months' time, the specific letter, he was asked to exercise this option.
You have a specific.
Yes, specific letter, that is on record.
Where is the letter? Show us.
Page 54.
My lord, may I submit one thing, my lord, before
Just a minute, just a minute.
special bench judgment is not applicable in the case of the petitioner. Because of that, my lord, the option 1 exercise, that is
No,
there.
but at the same time, when you exercise the option, when
Lots-
you find
lots-
that excess amount is coming to your bank account,
Lots-
why you have not said?
No.
Now, are you saying that this,
The government has suspected the authenticity of this government affidavit filed before the learner trial
no,
court.
but following this, when once again you asked for this, and what was his reply? After this,
No reply.
no.
After,
Did you ask
after,
for any
after this,
communication from your part?
Thereafter, nothing. My lord is kindly
after
come to,
nine,
it will be
after this 92 option, where from it is, how is it filed, before whom? Well, nothing appears. There is no receipt of the school, no receipt of the DI, nothing. Did he actually file it?
No. Will it not be evident from the payslip?
No.
Will not be evident
No,
from the
no.
payslip.
Basically, we will not discuss this.
my lord is the,
Now, after this, my lord, he says that I had submitted option in 1992. He annexes this in his writ petition. This does not bear, my lord, any receipt of the school authority or of the DI, nothing. He just annexes these
So
documents.
this
saying,
document is not in your record.
this is not in the government record either.
my lord, may I, in answer to my learned senior, my lord, come to page 53. My lord, that answer is clear, and also, my lord, is that they have took the resolution, they have annexed this document. Page 53, communication, my lord, made by the headmaster to the, my lord, the district inspector of the school, which is the, my lord, pension sanction authority. Enclosure, kindly see the service book of 2 copies, option form original.
Yes.
Option for original is of
Let them to produce, I have no case.
1985. That was a different form.
Mala, let them to produce, I have no case. Mala,
That's
kindly
a
come to
different
page 28, it is very clear.
If it is 85 form, not 92, then we'll reject it.
Now,
If it is
kindly,
the same 92, then you.
no,
then the
my lord, again, my lord, I am pointed out, my lord, kindly come to page 28. They took the resolution subject to result of, my lord, decision of the, my lord, higher authority, they will allow. Why, my lord? This is the, my lord, scheme says on the date of exercising option, my CPF account should be discontinued. And option 1 exercise, that is the final, that is the Bijoli Bhattacharya case, my lord, that has gone to the Honorable Supreme Court. And now our division bench, my lord, Ibrahim only case, it is not the duty of the employee to do what is the fate of his option. Option 1 exercise, it is the duty of the, my lord, the employer. Ibrahim only, I have cited those judgments.
No, but you see, come to page 57, clause 3. 57, clause 3. From the resolution, the school,
Yes.
the managing committee, it appears that Sri Banerjee expresses willingness to come to the pension. In response, the managing committee resolved to forward Mr. Banerjee's appeal to the higher. So, but since the last date of switchover to the pension was Ato, in terms of Ato, the said prayer was invalid. So I was requested to submit option to switch over. Did Ato, read a letter, this Ato of the school, but he did not submit his option and share any information with the school regarding the refund of the employee's share of contribution. Now, this letter you have not acted upon, 13 June 2014.
Now, when
So,
it
how
is
you have
filed,
not acted upon this letter of 13 June?
it says in terms of this.
You have not acted upon this letter of 13 June.
My lord, their later page, my lord, is the Lordship's page showing by the page 57.
13 June letter of 2014. Where is the letter of 13 June 2014?
My lord, the 13 June letter of the school authority.
Yes.
97.
On 13 June of,
13 June of 2014.
my lord, the 14 is not my case. My case,
They have given you a letter of 5th September 2014. Where is that letter?
my lord, I have not, because of that, there is the provision. My lord, option 1 exercise, unless and until my option is rejected, further option is not required. That is not accepted.
Since the government has not finalized it, so it was not accepted.
No,
If you
that
have
is their duty. That is their duty.
They do not do it for some reason.
So then I will not penalize.
No. At the same time, you got the benefit of.
Let them show any document that.
Obviously, you get the better benefit. You do not say that you have received 1 paisa on retirement and that and you receive the entire benefit.
I have not received. They let them to show. After retirement, I have received CPF amount which has been contributed by the employer. I have no case.
The entire
That is two cases.
That's a different issue. If the retirement benefits without the option is 1, If the retired benefits without the option, have you paid? Is paid, fine.
Let
If
them
you-
so.
No, if you accepted it, matter ends.
Then, my lord, I have no case. My lord, my submission
We
before
had
your
we had
lordship.
produced the Provident Fund register before the learned
No, no.
single judge,
What we need. to
showing
say
that he
is-
has withdrawn the entire amount,
My lord, this is a kind,
including employer share,
my lord, I am,
Including the entire
including
share.
interest.
Where is the
And-
document?
My lord, the records are not here today.
my lord, if they can show,
No,
your
but they
lordship
have-
thrown out this case herein now, my lord.
No, but they have produced a record.
My lord, let them to show before your lordships. I have no case. I will not argue before your lordship. My lord, there is the statement of the state government, that is the DI filed a affidavit. They have said, my lord, after that date, if they can show, my lord, I have come with the little short notes of argument, relying the relevant
They are not required. of this.
lordships.
If you have received it,
I have,
No. you may have exercised the option, but thereafter, if you continue to receive that benefit,
lordship,
then you have waived your right.
that wave of right, my lord, that can, now I suppose I will accept. I will accept. I will accept. My lord, let them to two document. If I accept the same, if they can show that after retirement, I have received.
You release all his admissible dues along with the
My
provident
lord,
fund dues.
1997 he retired. He felt aggrieved in after 25 years in 1922 he files his writ petition.
No,
After enjoying the entire money for so many years.
question is this, we are not going into that question. If he had retired without exercising option, let us put it this way, that he has not exercised his option. Then whether he has received his full retirement benefit.
He
That's all.
has received it.
You file an affidavit to that effect.
In the affidavit filed before the trial court, everything is mentioned.
But show us.
Lordship,
Sir, kindly come to page 34, it starts, our affidavit. Kindly come to page 35, paragraph 4. I submit that the instant writ is not maintainable since the writ petitioner neither during his service tenure nor thereafter in terms of memo dated 91 issued by government, etc., ever refunded the employer's share of CPF along with simple interest as well as additional interest to be calculated from the date of receipt of CPF up to the date of exercise of the option. I submit that the incident is not maintainable since the petitioner on the part of the petitioner in withdrawing the entire amount of CPF benefit is waiver on his claim for pension. Then paragraph 6, the suppression of material fact. Then 7, I submit that the respondent 5 and 6, the Ramakrishna Mission school authorities are neither necessary proper party, etc. Then we'll not have it. 9A. The writ petitioner joined the school in 61. As an assistant teacher, government of West Bengal on 16/12/91 issued a memorandum number in 85. According to the said memorandum, teaching and non-teaching employees of aided non-government education institutions who opted for contributory provident fund cum gratuity to exercise revised option for pension, including family pension cum gratuity, subject to the condition that the employer's share of contribution together with interest and additional interest shall be refunded forthwith. Now, B. On 5/2/92, the petitioner claimed to have submitted his option as a para 3B of government memo dated this. That is paragraph page 47 I have shown. The writ petitioner retired on 31/5/97. Then D. Although in the year 1990, out of 43 teaching and non-teaching staff of Odisha Ramakrishna Mission Shiksha Mandir, 42 opted for pension by discontinuing their memberships under CPF. But the writ petitioner continued his membership under CPF. In fact, since the writ petitioner till his retirement, as aforesaid, continued to be the member of CPF, the respondent school was also required to contribute the employer's share along with the contributions made by him. It will be clear from the following chart that on different dates the writ petitioner withdrawn the provident fund amount deposited under CPF. We have no vendetta against a particular teacher. Then the amount withdrawn is given. By a forwarding letter dated 2/7/97, the respondent school informed the assistant inspector of schools, secondary education, Diamond Harbour, regarding final withdrawal of provident.
You show us your P8, that's all.
Lordship,
Come to your file a status report, you show us that report. Come to page 39, para I. What is that report? R8 and R9.
R8 and R9. R8, my lord, is at page 56.
Page
56.
But where is that report?
My lord, No,
The very next page, my lord, 57.
No, that is not a report.
Not a
What is the status report?
this is the report asked for by DI.
What is the report?
My lord, this is 2511. The next page. Status report is page
Status
57. Kindly see the
That is the
subject.
status report.
R9, page 57. Status report regarding disbursement of retired benefits in favor of this retired assistant teacher. This is a missionary school, my lord, that has this missionary school has no any grudge against a particular teacher. Out of 43 staff,
Very well, take it off.
My lord, may I some?
No, sorry.
My lord is kindly
Get out,
comes, my
get
lord,
out.
kindly consider the one judgment of this
The
honorable
petitioner-
decision made, my lord.
The petitioner has
My lord,
filed the
reply to
petition
that, my lord.
after, when he retired,
My lord, 31st of May 1997.
this writ petition has been filed,
One submission. I came before, I am not CPF to GPF, I am not on that.
After the order is passed.
Only one submission. My writ petition should not be dismissed because of that. After filing the writ petition, they have released the gratuity. So now the delay period of the gratuity, I am entitled to get the interest. There is no lache.
When you have felt.
My lord, kindly see.
When you have released the gratuity.
2023. That is the page 33 in the writ petition. This is not my fault. As per the order of the single bench, interim order has been passed. That's why they have released the gratuity. Kindly see page 33. 2023, they have released the gratuity. At least my writ petition partly allow a gratuity entitled for the delay period. I am entitled to get the interest. That writ petition should not be dismissed.
But if you have delayed in payment of gratuity, then no, but you were allowed the gratuity. You have
2023, why after lapse?
Now, in that you should have, in which writ petition it was allowed, gratuity?
In this writ petition, kindly see page 33.
No, that you were entitled to.
Because of that, they have delayed in 25 years.
That you have to, that.
This kindly see the page 31. 31, the order of the, in that writ petition, my Lord Justice Basu directed to the authority concerned to pay whatever the amount he is entitled.
Which order?
I am not, my lord, really.
Which one? Which order?
The page 30, they have submitted all the documents to the district inspector of the school. 31 is the interim order which has been passed by my Lord Justice.
No, it was ultimately disposed of by which order?
My Lord, this order is in this writ petition because page 88 is the same writ petition. During the pendency of that writ petition, they have released the gratuity.
No, where it is recorded? Where is recorded?
The disposed on 28th
No, but have you prayed for that in your writ petition?
Yes, all retiral benefits.
No, where is this?
My writ petition, my specific prayer is this.
Oh, yes, gratuity is there, yes.
Lordship, with along with
gratuity is there. So you have to pay interest on that.
The state.
The state will take instruction on that. Regarding gratuity, there is no argument. There is no argument made before the learned trial court regarding gratuity.
No, but we find what is the order where the gratuity amount was directed?
Lordship, kindly see the page 31. It appears from the annexure section, the writ petition, though the relevant papers of disbursement of the retiral benefits of the petition were submitted by way of back on April 4th, 2001, before the district inspector of the school, the respondent number, but till date, the petitioner has not received the said benefits. The petitioner is now aged about 86 years.
When the gratuity is released, when?
Is kindly come to page 33. And 28th of November 2022. After filing the writ petition, pursuant to this order, this gratuity has been released.
When it was released, 20th.
The kindly see PPO.
My lord, that is in, yes, my lord, 30th of November 2022, he received the gratuity.
So he's entitled to interest on gratuity.
There is some delay, my
Lay
lord.
down.
I cannot say.
কি বললো?
No, their school has no, kindly come to page 30. They have submitted all the document 2001.
They submitted 2001. That's
So then they are laches. I have no the fault on the part of the petitioner.
2001. You have
2001.
Submitted
submitted documents in 2001. But for the timing, we'll hold from 2001 because we do not know whether you have all papers.
This is not mobile. That is the scheme says from the next date of retirement, I am entitled to get the all retiral.
From 4th April 2001 till
this
have required a signature, you have not given signature, we don't know.
It appears on there.
We cannot go back to the age of dinosaurs to find out. আচ্ছা অ্যাপিলের সাইডে ডাকো তো, অ্যাপিলের সাইডে ওকে ডাকো। এটা নিয়ে চলে যাবে, এটা নিয়ে চলে যাবে। আজকে আমার কোনো পয়সা
ভার্চুয়ালি আছে।
Yes, Mr. Kundu.
My lord, I'm sorry, my lord. I had a bad twist in my ankle today morning while it's coming down to court, my lord. I'm not there personally before all artists today. Rasi will kindly excuse me today. My lord, I'll be last occasion, your lordship was pleased to put to us a few questions. And this we have found out from our records as to whether or not my clients had taken steps for mitigation of the losses, because the basis of the claim of the petitioner is practically damages. To that, my lord, may I first answer one thing. We have got letters which are shown before lodges, but unfortunately, these letters have not been annexed by the sale, because the sale is the appellate before lordships. And my lord, the section 34 was also filed by sale. So owners was on sale to disclose these documents. Now I have got certain documents before me which are a part of the record before the learned arbitral tribunal. Am I audible to your lordships? Am I audible to your lordships?
Yes, yes.
Lord, I believe your lordship was not. Lord, may I 1 second start before what I said before lordships. My lord, the last occasion, it fell from our lordships as to whether my clients had taken any steps for mitigation of the losses and damages. I believe that was what fell from our lordships. To that, my lord, my answer was, yes, we had taken steps for mitigation of losses and damages, but my lord, immediately we had not given any documents, because my case was the issue of mitigation of losses and damages was not taken up or even argued by sale, either in the section 34 application or in the section 37 application. Appeal. Nevertheless, my lord, it was the duty on the part of sale, being the petitioner in the section 34 application and also the appeal, to disclose the documents by which your lordship's queries could be answered. Unfortunately, these documents have not been disclosed, but I have got a bunch of letters which were the subject matter of disclosure in the documents before the arbitral tribunal. Now, because these documents are not there before your lordships, I cannot just across the table show it to your lordships straight away. But nevertheless, I would like to emphasize to your lordships that these documents will clearly prove that apart from making several attempts.
Just a minute. Mr. Mitro, are you taking the point of mitigation of damages not considered or restricted yourself only to the clause?
Well, Milord, I have submitted my notes of argument.
But there is only one line on that.
Yes, but that I relied upon, and I've submitted the award is contrary to terms of the contract.
Yes, that is the main thing.
That's the main. And then arbitrator said that was
Loss of
reasonable,
profit. Loss of
reasonable
profit.
in assessment of reasonable. Contract. But that also we have challenged.
No, but mitigation of damage, loss of, because
I don't think, Milord, I have in the note I have not.
no, there is
In the
one,
note I
one
have-
line, one sentence. That is
Correct.
why we asked. No, in
Yeah.
your note, Mr. Mitra, I find once.
In the note we have not said.
That's why we have put this question.
No, in my note I don't.
No, if it is not there, maybe I have read it wrongly. Just, yes, 13.1.
Amar. My notes. Yes, I've got it in. Assessment of damages.
There, there.
New case of loss of profit has been introduced in the award. New case of loss of profit rate of 15% has been made out by the tribunal, which was contrary to the case of HTC and made in a submission to arbitration.
So your case was that loss of profit is based on their construction of supply of reasonable quantity.
A loss of profit is based on an assumption.
On reasonable supply of reasonable.
And
Not on mitigation of
no,
damages.
no, no. Loss of profit on that. And Milord, my case, I mean, they have gone beyond the scope of
Yes,
difference.
that's it.
Beyond the scope of. Well, I confine to the note, Milord.
Then there is
And
there is no requirement to argue on mitigation of
No,
damage.
no. And I shall give reply to the notes he has submitted. Milord, I'll just marginally make note my answers to the note.
Yes, yes.
When, even when he finishes.
No, my lord, to be very honest, my lord, I'm in a very precarious situation, my lord, because of my egg, my lord, food egg, my lord. But anyway, if I have to submit with your lordships with regard to mitigation of damages, then I shall continue. If your lordships.
Firstly, you address us as Mr. Mitra has clarified. His challenge to the loss of profit is based on the presumption of reasonable supply of the reasonable supply of reasonable quantity, which is not contemplated in the agreement. That was Mr. Mitra's submission.
Yes,
So,
my lord.
first address us on that, on the construction part of it.
Lordships. Now, my lord, I'll place reliance on 3 or 4 paragraphs or clauses of the terms and conditions, as also instruction to tenderers. My lord, your lordship will kindly come to the instructions to tenderers, that is on page 409. That is perhaps the last volume, 4th volume. Now, your lordship will see at the very beginning that this is instructions to tender. Before that, yes, your lordship will see the next page. Invitation to next page, my lord. Page 410, 408, my lord. Sorry, 407, 408, my lord. Your lordship will see invitation to tenderers. Lordship kindly comes to page, my lord. 4010. 410, my lord. Now your lordship will see paragraphs 4. Paragraph 4 at page 410. Am I not got it, my lord?
Yes, yes. Yes.
Mr. Basu will read the two clauses, clauses 4 and 5. Clauses 4 and 5.
The estimated quantities, my lord, supposed to be handled during the first year of operation of the contract are expected to be as under. My lord, pig irons 5,000, receipt and delivery is 5,000, steel is 250,000, delivery is also 250,000, total comes to 255,000. Then, my lord, clause 5, the estimated quantities for the first year of operation of contract are only for the purpose of finding out the value of the tender, and sale is in no way liable if the actual quantity of work differs from the estimated quantity indicated above.
So, my lord, sale does not in any manner whatsoever says that the estimated quantity put to tender would be 0 or anything which sale wants. So, my lord, first is an estimate for the purpose of assessing or helping the contractor to assess as to what would be the amount which he should quote as a rate for in the tender, so as to give him the best possible scenario for being the lowest tender. Now, my lord, this is a peculiar sort of a tender where every parameters of the tender, including the materials which is to be handled by the handling contractor, has been fixed by sale on the basis of the disclosures made by sale in the terms and conditions and waivers of the tender. I will refer to before lordships.
A lot of. You are not clear, Mr. He intercepted. It's not very clear.
Again, it is frozen. The screen freezes.
If the volume can be reduced, decreased.
You try whatever you want, suggest to my.
ভলিউমটাকে একটু কমিয়ে দিন, একটু কমান।
দাঁড়িয়েছে শোনা কি হলো কথা, ন্যাচারাল ভলিউম তো ভালো আছে, ন্যাচারাল ভলিউম তো।
Yes, Mr. Kundu, can you hear us?
Again, your lordship is very much audible, but I don't know whether I am audible or not.
Sometimes the screen is freezing or your voice is getting a little
Yes, yes.
Now, my lord, your lordship will see, so my lord, on the basis of the estimated quantity which has been laid down in the document, your lordship will thereafter straight away come to page, before I go to any other pages, your lordship will straight away come to page 496.
495.
495. 495. Your lordship will see it's a quantity which is to be delivered. And this is the quantity which has been fixed by sale in the tender terms and conditions. I will only have to quote the rates based on the estimated quantity put to tender. And your lordship will see that these various items of handling items comes to 2,55,000 tons. Your lordship will see 1, 2, 3. It all comes to kindly takes it from me because I've been doing this matter since long, my lord. It will totally amount to 2,55,000 tons. So delivery is for 2,55,000 tons. Similarly, my lord, your lordship will find and my lord, lordship can give me one moment, my lord. Page.
No, what do you want to say on this document?
Yes. Kindly comes to page clause 4 now.
No, 495 is a schedule of operation. And the rates.
Schedule of operations and rates. Rates.
Yes, operation and
So,
rates.
my lord, yes, that is important. So, my lord, when the
These are all being filled up by you.
No, your lordship kindly, that's what I'm saying, your lordships. Your lordship kindly comes to clause 4 once again at page 410. It says, my lord, delivery is to be 4,55,000 tons. The breakup is been given by sale, but the total amount of delivery is typed out. That particular operational schedule is handwritten. But last you will see, sales own estimate a typographical document shows that sale has given an estimate of 2,55,000 tons delivery and 2,55,000 tons receipt, amounting to 5,10,000 to be handled by the handling contractor.
Where do you get it?
Rasu will see. Clause 4, Mr. Basu will once again read your losses at page 410.
Page 410, volume 3, clause 4, which I had shown it to your lordship.
Clause 4. Watch. Oh, yes. No, this is what the first year says, but the form you are shown.
No, first year, I'll come to that also. This is a jugglery of words which will not.
495 shows 250 metric tons.
Then it comes to 2,55,000 metric tons.
No, what is this? 250?
255,000 metric tons of delivery.
Putting into customer is 250. This is 250 metric tons. 250 metric tons, not 250. Where do you get it?
Your lordship will add up. I have added it up. Your lordship can take it. Mr. Mitro can ask his junior to add up all these quantities.
Total quantities.
Add up to 2 lakhs.
The entire quantity put together. That is what you're saying.
Yes. Similarly, Mr. Basu will also show the delivery, the receipt part of it. The receipt will also be shown to be 2,55,000 metric tons. So, my lord, schedule of operations and rates. And the schedule of operations and rates for the estimated quantity which is to be handled by the handling contractor has been laid down by sale, not by me. And on the basis thereof, in any business transaction, unless the quantity of materials is not made known to the person who intends to put in his rates, and it's a rate contract. This is important. This is a rate contract. So, Manat, without the knowledge of the quantity of materials which I am supposed to handle, I will not be able to put in my rates. And that is what the learned arbitrators had recorded in paragraph 6.8, 18 and 19, 17, 18 and 19. In the award. And we have shown it to Lordship, but Mr. Basu will show it before Lordship once again. Unloading. Malad now kindly comes to page 489 now. I have shown you the delivery part of it. Now your Lordship will see the unloading part of it. Page 489. Now comes the unloading part of it. 2,35,000 tons. These figures have not been put in by HTC. It is sales estimate, which a handling contractor is expected to handle. And for that purpose,
Where is the pleading in respect of these documents?
which documents, Malad?
Is 489 onwards?
Malad, your Lordship, before that, your Lordship kindly comes to page 486 once. Before I show your Lordship kindly comes to page 486. Your Lordship will see the entire contract consists of, Lordship, give me one minute, Malad. 486, your Lordship will see. Oh. Yes. Has your Lordship got page 486?
Yes, yes.
Your Lordship will see that all these clauses up to clause number G, including the circular offices, instructions to tenderers, terms and conditions, and various salesmen and operations are a part of the entire contract. So when we read the word contract, it will include all these clauses. So when a handling contractor is expected to deal with all these clauses, certainly, one stray clause which has been harped on by Mr. Mitro and his predecessors before this Hon'ble Court and also before the arbitral tribunal certainly not hold the sway, because all the various clauses, including clauses which have different dimensions, will have to be read together harmoniously to ensure that the handling contractor is given the estimated quantity put to tender, or at least a reasonable part of it to handle. Not a purchase 3.7%. And all these issues have been elaborately dealt with by the arbitral tribunal. I will once again take your lordships with the help of Mr. Basu through all these clauses. But suffice to say, I'll now take your lordships to the various terms and conditions of the tender, including one clause, which is important in the light of.
Please show us that these documents from 489 onwards. What was your pleading and how these documents were tendered?
This was tendered in the arbitral proceedings.
No. It must have found place in your evidence or affidavit or something like that.
This was never disputed by any of the parties. This is sales own documents. Both the parties have signed this document. You will see on each and every page.
No, we are not done that. How these documents were introduced must be in the pleading, in the evidence. How we wanted to see.
In the statement of claim by sale itself. By sale itself. Then I will have to show your lordships the statement of claim filed by sale, which is not there with me today. But it was sales section that application of your lordships. It was sales arbitration proceeding before the arbitral tribunal. So enter owners was on sale to disclose. No one has disputed the correctness or otherwise of these documents. Now, if your lordship wants me to show, I'll be only too glad to assist your lordships. Then in that event, I will certainly have to.
No, you proceed.
The question as to whether these documents have seen the light will be evident the fact that if your lordship goes to the award itself, the evidence which was taken from time to time from various witnesses of both the claimant as also the respondent will clearly leave no room for any doubt that these clauses have never been disputed either by SEL or by HTC. The only grievance of SEL, and that was repeatedly recorded by the learned arbitrator tribunal as also by the Section 34 code, that SEL did not dispute any of the decisions with regard to the calculation of the damages by the arbitral tribunal. I'll show your lordship those paragraphs. But before that, I'll take your lordships to page 411 once.
May I intervene once? Already your lordships is inquiring as to how these schedules were introduced into the arbitration proceeding. Your lordship takes us the supplementary affidavit, which is the paper book, which is there with your lordship, volume 1. That was annexed with the statement of claim.
Filed by SEL.
Yes.
Filed by SEL.
There are supplementary. There are supplementary records.
Volume.
supplementary paper. Lordship sees so your lordship would see, my lord, the whole of the contract has been annexed. And your lordship sees, my lord, page 106 onwards, all the schedules which Mr. Kundu is referring to, that was annexed. But in fact, my lord, that comes along with the statement of claim, which is the first page 1, my lord, of the supplementary paper book. Your lordship comes to page 5 of the paper book. Your lordship would see the pleading. Copies of the documents forming the contract are annexed here to and marked A. That forms the whole of the contract which has been there, Miller, from page.
So from page 106 onwards,
Lordship.
this was what according to you, the sale put this
Yes.
and corresponding rates were put. It was before the contract was executed or during the
invitation?
No, before. Because one on the basis of the rates quoted by the various intending contractors, the sale went into the various rates and then ultimately came to a conclusion that HTC was declared to be the lowest bidder.
No, these documents were form part of the contract or the work orders.
Entire thing. Entire document is a part of the contract. Entire document, তাই তো? কবে করেছিস সেগুলি? সই কবে করেছিস? Out. Control মারছে তো?
Onwards.
I can
required to fill up or the work orders.
No, these are the
not
parts
work
of the
orders.
original contract.
Where they have put the quantity.
Yes, which Mr. Kundu was showing to you.
Very good. Very good.
Manad, may I indicate, Manad, once it was declared that my client was L1, thereafter, Manad, the contract was signed by both the parties. And with effect from 23rd of November 1996, the contract came into existence. Manad, I shall assist lordships in yes. Your lordship will kindly come to page
26/8/96. 26/8/96.
Your lordship will come to, Malad, your lordship will come to the last page of the contract. Your lordship will come to, there the date is.
Whatever the schedule you have shown,
Lordships.
date along with clause 4 and clause 5.
No, not only that. Then the NIT itself, that is an instruction to tender. Now your lordship will see the NIT now. Your lordship will see the NIT now. That is again at page.
this invitation to tender,
Invitation to tender, and thereafter, my lordship, kindly come to page Mulad, the third paragraph, Mulad, 413 onwards.
But sometimes your lordship's voice is not coming on the microphone. That
yes,
is
this is coming.
But it's not coming because in this live streaming or in the virtual mode, sometimes it's getting diverted. I have heard it sometimes because of the shortness of the microphone.
Tell us something. When do you think Mr. Kundu will be? How long does he require and when will he come here to address?
Your lordship would kindly
No,
ask.
I'll address your lordship on Monday also if your lordship wants, but I'll just have to have take it.
Mr. Kundu like this now, Monday we cannot, because this is a.
Because, bro, may I only indicate one thing? May I indicate one thing? Because, Mulad, I was addressing your lordships on one issue. Thereafter, Mulad, certain things fell from your lordships, to which I will have to address, because it is my duty. It is my duty to assist your lordships, Mulad, whatever queries which your lordship may have. So, Mulad, it's my duty, Mulad, because I know that, Mulad, your lordship will thereafter come to the next clauses 4 and 5 in the, and then you also will see the change in the working wordings. First is an estimate, and then is an enabling clause. One is for assessment and one is for enabling. So two different clauses conveying the same meaning, same quantity. All of the base have said, I have got not a iota of right to change the word or semicolon of the contract.
No.
Your lordships, when it comes to page 415, then I'll show to your lordships the changes in the nomenclature of clauses 4 and 5 now. Oh, that's it.
Yes.
Rasul Gadi comes to Manor. Pages 4.0, clause 4.0 at page 416 now. Page 416. The Rasul will now see the change, subtle change in word now. Mr. Basu will read the clause now.
4 point?
Well, it's clause 4 at page 416.
Gotcha, clause 4. Yes, that you have placed.
Yes. But on the very initial.
No, this is.
The very initial stages, we had argued, in fact,
Yes,
clause
these
4,
clauses
5,
were, yes.
clause 4 and clause 8.7.
Yes,
That was, we argued at the at length.
So
In fact, that has been
so
argued.
don't repeat, please don't repeat.
I know.
No, I'm only saying that there are two subtle changes in the terms and conditions of the 4.1 clause in the invitation to tender and the NIT. That's what I'm wanting to show to your lordships. Kali comes to page clause 4.0 at page 416. And compare with the 4.0 at page 410. You will also see both are different. Now both are different. Mr. Basu will read the clause 4.1 at page 416.
Mr. Basu, why don't you do one thing? The clauses you, just like what Mr. Mitter has done, why don't you give us the clauses on which you are relying upon?
So that's there in the notes.
They're in the itself, the fun notes and arguments, your lordships.
So that is the easiest way.
Your lordship, then your lordship takes the notes and arguments, yes.
That is the
That's your lordship.
Yes, show us. That's the easiest way of doing it.
Your lordship will.
If you have set out the clauses, please show us. Yes.
Yes, we have set out the clause.
Yes.
Mr. Basu will show it to your lordship straight away.
The page 3 is the clause 4, clause 5, yes.
No, there are clause 2, clause 4 and 5 have been.
At page 3.
And is that page 3 being the part of the invitation to tender, and the NIT is a different clause altogether. That's what I'm saying. So we have said out both the clauses 4 and both the clauses 5. Mr. Basu will show it to lordships.
We followed. You want to say that the clause 4 in NIT and this instruction tender are different, slightly different.
No, different in the sense that the NIT gives you further right to claim this amount because it becomes now an enabling clause. First was an estimation, now it's an enabling clause. First an estimation to help and assess the contractor to come to the rates. And after the rates have been fixed, it becomes an enabling clause by which sale is not required. To put in the quantum of materials which it had printed in the NIT. And along with that, as a fortification of my argument, I have relied on the schedule of operations and rates. And the operations of the various types of handling materials and the handling quantum of handling materials was fixed by sale, not by me. Being a rate contract, I had to quote my best price for 2 years. So, my lord, I could not have perhaps your lordship is perhaps reading at page 1 of the notes.
Yes, we are looking at the notes.
The various clauses which we are relying on are these clauses.
No, you see the NIT, you are first relying upon clause 4 of the notice inviting tender.
Notice inviting.
There it is said proposed to be handled.
Proposed to be handled.
Handled during the first year of operation.
First year of operation. And then we had said that.
Then 5 says that whatever would be the estimated quantities for the first year operation is only for the purpose of finding out the value of the tender.
Oh.
If the estimated quantity is say 4 lakhs, whatever the commensurate value would be, so this will be the value of the tender. What will be the commensurate value of it?
That's it.
And sale is in no way liable for the actual quantity of work differs from the estimated quantity.
If it differs, I'm emphasizing on the word differs. I'm putting special emphasis on the word differs. Difference.
Yes, the actual quantity of work differs.
Differs.
Because when you are giving your estimate, then you take that for the purpose of your what would be the quotation.
Yes, obviously there has to be.
Whatever, suppose it say the first year 4,000 metric ton, then you have to give a quotation for that.
Yes.
Sale says that quantity or estimated quantity mentioned, which you take as a measure for valuing your what would be your quotation, that when the contract is ultimately given to you, and if there is in the first year, it is less than 4,000, then it may differ. There is no warrant, there is no promise that the actual quantity of the work may differ from the estimated quantity. So suppose if you give 4,000, suppose they say estimated 4,000, and ultimately they gave 2,000, and you make a quotation of 4,000. But sale will not be liable if ultimately it appears that you get 2,000.
With respect, perhaps that may not be. Once your lordship reads the entire contract as a whole, your lordship is looking the contract based on only one clause, because of the fact that my main materials, equipment and labor, which I have to keep in readiness for the next 2 years of operation, are based on the quantity which has been put to tender, that is 5,10,000 metric tons, and said that I have also written the various clauses. I'll show your lordships. And sale has said in no uncertain terms that he may either have 50% ownership of these materials and or hire 50%, nothing more, machineries. But I will have to ensure that at any point of time, I will have to keep in readiness the main levers to handle the entire amount which may come at any point of time, because it's a 24 hours, 24/7 job in the stockyard. The trains might come at the dead of the night. It may come in the stroke of the afternoon. But you will have to keep at that point of time. If I do not have the sufficient men and materials, then I will be put to damages, damages, and other costs. Now, when I read this thing, and then I'll show to the sale itself had in a letter, the sale itself in the Raju gives you one moment, Lord. Given us what was to be written and what was to be done. Raju, kindly come to page internal page 56.
So what?
I'm just asking for a, let me give you one moment. Profit. Yes. Manad, your lordship will come to Mr. Basu will show to your lordship the sale itself in the NIT, and this is a factor which I will have to, as a contractor, take into consideration. The various components which I will have to maintain, including my share of profit, which was spelled out by sale in the contract itself. And I'm entitled to that amount. The lordship will kindly come to page, my lord. Mr. Basu will assist your lordship, my lord. Internal page 56 of the terms and conditions of the tender. Internal page 56.
Of the
Terms and conditions of the tender. That is clause number 6. 6/2. 6/1. 6/2. 6/2. 6/2.
page 56 of which volume? Hey, volume 1, brother. 56.
Page 56, internal page 56, Mr. Basu will assist your lordship with the page number of the volume which is before your lordship.
No, page 56.
Page 50.
কোনটা? This is Supreme Court একটা কি? You are showing the award.
No. I'm showing the terms and conditions of the tender. Clause 6.2.
Which volume?
That was in volume 4, I believe, most probably.
But 6.2 is in volume 3,
3, sorry.
241.
Your Lordship will kindly come to the computation in which the various components as to how it would be expected to be utilized and whether the contractor would be entitled that this amount would be on account of labor, and ultimately you also will see sale itself has laid down the profit. %. Mr. Basu will assist your Lordship in reading the, your Lordship will see that
Labor, fuel, overhead.
your Lordship will see 4 components: labor, fuel, overheads, and profits. These are part of the contract. So, intending
Sir, Mr.
deliver,
Kundu,
how
much time will you take?
if this Manat with utmost Manat and deep humiliation, if I may say, Manat, but if these questions come to
Please do one thing, give us 1 or 2 page on the clauses you are relying and where it is available. Only the clauses. And the pages, only the, set out the clauses. Accurately set out the clauses. Only the clauses. We don't require anything. And where the pages there. And accurately set out the clauses. Don't make any mistake on that.
then in that event, it may not be within 2 pages, but I can that's you know. It may not be in 2 pages.
No, clauses, only the clauses.
No, even then also, Manat, even if the font is
2 clauses.
less than Manat, it may not.
No.
Yes.
দিয়েছে নোটস ক্লজ গুলো দিয়ে দিয়েছে
We'll just set out the clause and the page of the paper book where it is there.
But you set out the clause
I'll set out
accurately.
I'll quote the clause exactly what is there in the contract and the page number of the paper. Jani. Not
Mr. Basu, just find out how much more time Mr. Kundu will take.
Manat, these questions, since it's falling from our Lordship,
Mr. Kundu,
I'll have to.
There is no question falling from the bench. Bench is.
Manat, I'm not saying, Manat, I can take I can finish up my matter in 10 minutes.
Please finish it. We want to.
Wants me to do so. But Manat,
we'll not ask you anything. You just finish it off on a day you fix.
The
Otherwise, very
notes of
difficult
argument has been submitted. May I give to deal with that, and I go off the seat. Mr. Kundu has given 2 notes of argument.
2 notes.
Number 1 and short notes. All both are short notes. This is number 1, and then supplementary notes.
Right.
It's all in writing.
All in writing.
I think
we have also prepared 2 notes, one of final notes and one Manat, a note only dealing with Mr. Mittu's argument. There are 2 notes. from our side as well.
Just a minute, just a minute. We are utterly
I've
confused.
got two notes, supplementary notes.
Yes.
Short notes.
Yes,
Manoj, the supplementary note deals with their arguments and the short note is our.
that's it. Two notes are there.
Now you want to file anything else?
No.
Mr.
Manoj, only
Mitra,
the
you
one
want
that
to
has
deal with
fallen from
this?
Justice Sen.
So may I just deal with this note and we be relieved.
Yes.
That can you take the note number 1?
Not
Oh,
330.
Manoj, I hope that I will not have to address your lordship in the issue of mitigation.
Yes, Mr. Kundu.
I hope that I will not have to address your lordships on the issue of mitigation of losses.
No.
Develop lies.
Supplementary note কোথায় আছে? Supplementary note আছে কতগুলো নোটের জ্বালায় না নোট আর নোটের শেষ
Mr. Basu, Mr. Kundu
supplementary note.
had asked us and we have told him there's no need on mitigation.
this note,
Well, in that event, what has fallen from your lordship today, in fact, everything is there in the note.
everything is in note.
We have argued that 4 clauses, basically 4 and 5, 4 and 8.7. We had argued it at length. In fact, nothing more remains. And on the last occasion, in fact, we have shown it from the award that the arbitrators had gone into how he has calculated.
If Mr. Kundu doesn't want to address any further, we have no issue.
We have no
Speak with
issue.
him once,
And
Manoj.
if you think, no, if you think it is mentioned out here, just show it.
Then
to
we'll
us.
just simply make
Which is
it
the
CAP.
clause? Tell us, which is the clause that you're referring to?
Clause-
I've got your notes in front of me.
Clause 4 and 5, it's there.
Clause NIT clause 4 and 5 and the
And
terms
also,
condition clause 8.7.
And the notice inviting tender, clause 4.
Oh, this has been have been read out so many times. Lots of other Mr. Basu can read out the notes and place the note to your lordship.
Well, we have argued more than the
No,
notes.
no. We are extremely happy if you conclude today because it's very difficult to assemble. But unless Mr. Kundu thinks that he comes and
Manoj, because I will also have to deal with Mr. Mitro's argument, which I have not had the occasion to deal with the argument.
The note dealing with my
No, I have, but I will have to also show to your lordship, Manoj, that the argument made by Mr. Mitro perhaps does not hold water. So, Manoj,
Mr. Kundu, we are comfortable with both. If you want to finish it off today, we are happy.
lordship kindly gives me, had it been 4:30 today, I would have certainly have finished it off.
Because
But as your lordship said on the last occasion, 2 hours, and your lordship used to fix that matter as at 3:30, then the matter has been settled fixed.
Respondent, full stop, list this matter for further hearing on. Date that they can subject to.
To be notified letter. Notified letter. Notified letter.
I shall only confine myself to Mr. Mitro's arguments.
মানে কোল্ড স্টোরেজে না চলে যায় এনে দেখিয়ে নেবে
এটা
খুব তাড়াতাড়ি করে
হ্যাঁ,
দেখে আমার অ্যাপ্লিকেশনে কোড অফিসার আছে তাহলে অ্যাপ্লাই করে দেবো
এটা প্যাক করে পাঠাও।
আমার স্কুলে আমার আলাদা করে কথা আর মুখে হয়েছে
এই 3টা বই একবার আমাকে কাউকে আমার লোকজনকে বলে সই করে। No, but I just like the this. আমি 5 জন আছি আর কি করবো? বন্ধ করে দেবি ভিডিওটা
এটা আমরা কি রিপ্লাইটা দেখি সেটা কি এটা করে রাখবে তোমার পাশে নোট আছে ওকে দিয়ে দিতে দুটো নোট
Very good. Date should be notified later on.
Yes.